Good morning and welcome to the South Carolina Public Service Commission. We are here today in dockets number 2023-8-E, Duke Energy Progress, LLC's 2023 Integrated Resource Plan, and docket number 2028-10E, Duke Energy Carolina, LLC's 2023 Integrated Resource Plan. In this hearing, you will often hear referred to one thing as Duke Energy and the Integrated Resource Plan as referred to as IRP. First, do a roll call. Commissioners, all commissioners are here in the courtroom and we are ready to proceed. I will first ask our staff counsel to read the docket.
Thank you. Thank you, Mr. Chairman and Commissioners, and thank you for all who are here with the Commission today, virtually and in person. As the Chairman mentioned, the hearing before you today is in docket numbers 2023-8E and 2023-10E. This is the application of Duke Energy Progress, LLC and Duke Energy Carolinas, LLC regarding their 2023 Integrated Resource Plans. The hearing scheduled today was noticed by the clerk to be held today beginning at 10 a.m. on September the 16th and continuing each day until completed. Mr. Chairman, upon inquiry of all participating counsel of record previously this morning, counsel for the parties of record are present and available for your call of appearances. The docket is ready, Mr. Chairman.
Thank you, Ms. Wessinger Hill. Next, I would ask the parties, starting with the company, to introduce themselves for the record.
Good morning, Chair Powers, Vice Chair Williams, members of the Commission. On behalf of Duke Energy Carolinas and Duke Energy Progress, I am Sam Wellborn. I have with me this morning Lyle Trawick of Robinson Gray and Brett Breitschwert of McGuire Woods.
Thank you. Walmart.
Good morning, Commissioners. Stephanie Eaton here on behalf of Walmart.
South Carolina Coastal Conservation League, Southern Alliance Clean Energy, Upstate Forever.
Good morning, Commissioner Powers, members of the Commission. I'm Kate Mixon here on behalf of SACE, CCL, Upstate Forever, and Vote Solar. And with me here today are Thomas Gooding and Emma Clancy.
Welcome. Carolina's Clean Energy Business Association.
Chairman Powers, members of the Commission, I'm Richard Witt representing SECEBA. Also representing SECEBA virtually today, and he'll be here later in the week, is John Burns, the General Counsel of SECEBA, who's been admitted by the Commission pro hoc vici.
Okay, thank you. And Sierra Club.
Good morning, Chairman Powers and members of the Commission. Dorothy Jaffe and Robert Guild on behalf of the Sierra Club.
Thank you very much. And I think that's it, except Office of Regulatory Staff.
Good morning, Chair Powers, Vice Chair Williams, and members of the Commission. Donna Rainey on behalf of ORS, and with me today is Chad Torrey and Joshua Austin.
Thank you very much. I understand we have three interveners that have been excused from this hearing: Total Energy Renewables USA LLC, Clean Energy Business Association, and Nucor Steel. Will not be attending. I understand there are several preliminary matters that we need to proceed with. And
Mr. Chairman, this is John Burns remotely. I hate to interrupt, but I just want to clarify for the record, you stated Clean Energy Business Association was excused, but I think it's the Clean Energy Buyers Association. Pardon the confusion, but I want to make that clear.
Well, welcome. Glad to have you.
All right, thanks.
There's several outstanding issues to deal with, and let's start with one being the Duke's request for witnesses to be able to speak with counsel after testifying on direct and being resworn for rebuttal, and that of course would apply for any and all parties. There have been a lot of correspondence in the last few days, not much of a weekend for some people apparently. I wanted to see first, is there any disagreement with that before we bother with arguments on that? Any agreement, disagreement from any of the parties? Okay, well, we're going to grant Duke's request and allow the witnesses to come down to be re-sworn. What the commission may do, though, however, and it's up to each individual commissioner, but we may reserve, so we certainly reserve the right and may not ask questions until after we hear the rebuttal. Not just for judicial efficiency, but just to have the full testimony before hearing the, or proceeding on that. Just so people will know that it's not that we're interested. When you put up your direct, there may be a lot more questioning after that. And of course, all parties may proceed the same way. The next question up before us would be ORS's motion to strike Duke testimony that offers legal conclusions, and that being testimony, certain portions of testimony of Heather Shirley Smith and Mr. Glenn Snyder. ORS, this is your motion. I'd like to hear from you first.
Thank you, Chair Powers. Good morning. Joshua Alston on behalf of ORS. Chair Powers, members of the Commission. I'll try to be as brief as I can. The South Carolina Rules of Evidence 704 and South Carolina case law in Hamilton and Dawkins establish in general that expert testimony is inadmissible. Further, testimony that attempts to usurp the trial court's role is inadmissible. There was a significant shift in Duke Energy's language used in rebuttal testimony. You will possibly be hearing some testimony throughout the hearing, and additional information in the companion motion from Attorney Torrey to possibly explain some of that shift in the testimony. However, there was a drastic shift in the testimony language in rebuttal. The company will argue that ORS opened the door, but a review of the cited testimony and the report will show that this was of a nature similar to the testimony advanced by the company in Duke's direct testimony. ORS is not seeking to strike any of the direct testimony from the company. Also, the company could have filed a motion to strike if it really had an issue with ORS's direct testimony. The company will also tell you that the rule against conclusive legal opinions is diminished because the commission is not a jury but a panel of experts. While we would agree that the commission is less likely to be confused by the issues, that is not the test of whether the testimony is admissible or inadmissible. The company cites to numerous unpublished cases that cite to 4th and 7th Circuit jurisprudence on federal rules, which are different than the state rules. However, Dawkins is clear. Dawkins, a 2003 Supreme Court case, involved an affidavit in support of a motion for summary judgment. A motion for summary judgment is a motion where a party argues that a case should be dismissed as a matter of law, that there are no facts in dispute. In that case, an expert filed an affidavit seeking to establish certain facts in order to survive that legal motion. A trial judge, who I think we could all agree is the person that is least likely to be confused by any issues, nevertheless determined that that affidavit had inadmissible testimony that was of a legally conclusive nature. I would argue that an affidavit is very similar to pre-filed testimony, and ORS would request that the company or the commission strike the identified excerpts of the Duke witness testimony, including the supplemental direct of Heather Shirley Smith, the rebuttal testimony of Heather Shirley Smith, and the rebuttal testimony of Glenn Snyder. Thank you.
Thank you very much. Company like to respond.
Thank you, Mr. Chairman. Good morning, Commissioners. Lyle Trawick of Robinson Gray on behalf of the Commission. Would just like to respond briefly to Mr. Alston's motion on behalf of ORS. ORS did open the door on direct. They have not moved to strike any of the company's direct testimony. That's all in the record. What the companies did here was specifically respond to specific portions of Mr. Salter's and, in part, Mr. Hyatt's direct testimony. So under case law, ORS opened the door. And so irrespective of whether the responsive testimony was admissible or inadmissible, it comes in. And that's directly from Daniel v. Tower Trucking and the Simmons cases that we cited in our brief. ORS, however, says that Mr. Salter's testimony simply discusses what the IRP statute says and how the unique requests of Duke Energy go beyond the restrictions of the statute. That sounds a lot like legal testimony to me. And so, respectfully, we would ask the commission to reject this rules for thee but not for me approach. Furthermore, Smith is a regulatory and policy expert. That's actually in her job title. So she's not exactly giving legal conclusions here. She's contextualizing the policy as set forth by the General Assembly in this extremely complex and technical environment of utility regulation. We have to argue what the statute means to us and how we have met our burden of proof in order to shoulder that burden. And so necessarily in these proceedings, we're going to be talking about legal issues and applying the facts to the statute. And you know what that is? That is the textbook definition of an ultimate opinion under Rule 704 of the South Carolina Rules of Evidence, and that's allowed. Furthermore, we did not only cite unpublished cases in our brief. There are published decisions from the United States Court of Appeals for the Fourth Circuit in which South Carolina sits. And I've cited in numerous briefs to this commission before that our courts have often looked to federal case law on Daubert motions when challenging the reliability or admissibility of testimony from experts. So those are all fair game. And so ORS is free to argue in a post-hearing brief how the commission should weigh this evidence. But all of their arguments go to the weight, not the admissibility. And with respect, Mr. Alston gets the preservation doctrine exactly backwards. Rule 103B of the South Carolina Rules of Evidence requires a timely objection. No evidence is in the record yet. Evidence does not become evidence in the record until the commission accepts it as such and swears in the witness. That's under Regulation 103-825A. And furthermore, case law is crystal clear in South Carolina that a pretrial motion ruling on evidentiary matters is not a final ruling. You still have to raise a contemporaneous objection when the party tries to offer the evidence. If necessary, we're prepared to do that, but we waive nothing by not trying to waste the commission's time with evidentiary motions practice. We elected to allow the companies and the ORS to put forth their competing positions, and you can decide who wins on that. And respectfully, we think that's the better course here, and so the commission should defer ruling on this until a final order. I do, however, while my colleague goes and puts up a prime example of some of the testimony challenged here on the ELMO, I want to invoke some other rules of evidence. We've got here a qualified expert who practiced before the commission for years, offering opinions about South Carolina policy. That's allowed under Rule 702, and Watson v. Ford Motor Company, the seminal decision the Supreme Court of South Carolina set forth for admission of expert testimony. Rule 704, again, allows ultimate opinions. Rule 401, clearly this is relevant evidence. Look at their motion for declaratory judgment. These issues are very much at play here, and they're important for the commission to decide. Look at Rule 403. ORS can't argue any prejudice because they were allowed to respond in surrebuttal. And so the danger of unfair prejudice certainly does not substantially outweigh the probative value, if any, that the testimony offers. And here, Ms. Smith's testimony offers a lot of probative value. I think the example on page 48, line 20 to 49.4 really is a good one to show what they're trying to strike here. Ms. Smith is simply explaining what the companies are asking the commission to do and stating our position that it's unreasonable to assume that the company's management would not look to the IRP as a guide for decision-making in the future. That's not even legal testimony. That is a position of the companies, it's a statement of fact, and it's part of a request for the relief in this proceeding. And so for all these reasons, we would respectfully request that the commission deny the motion to strike. Also, he didn't hit as much on Mr. Snyder's rebuttal testimony, but I did want to briefly hit on that too. None of the cited portions represent legal conclusions. They're simply articulating what the companies are seeking from the commission and why they need it. And they also represent ultimate opinions under Rule 704. So for these reasons, ORS's motion to strike should be denied.
Thank you, Mr. Trewick. Stay right there. This is a hard one for the commission because, you know, it is our prerogative as far as what the law is. We do not need to be instructed on the law, and I feel like some of that may be that way. Tell me how you reconcile all this with the Dawkins case that involved Professor Freeman.
Sure. Yeah, and I'm familiar with that one and have cited it before. Dawkins merely sets forth the general rule that in general, legal conclusions are not admissible in South Carolina. In that case, Professor Freeman, the late Professor Freeman, submitted an affidavit to try to survive summary judgment to try to prevent the case from getting dismissed. Here, we're here at the hearing ready to go for witnesses to offer testimony. There, he submitted an affidavit that was more akin to a brief. This isn't a brief. This is merely offering ultimate opinions on how the companies meet the statutory framework established by the General Assembly. We've got 7 balancing factors that we have to meet, and that's part of our burden of proof. So to not be able to discuss it seems anathema to the intent of the IRP process as set forth by the General Assembly. So that's a major distinction there. We're also in a very highly technical regulatory environment in which lots of laws are at issue and go on the scale. We're merely advocating for our position. We're not invading your province as the fact finder or decider of questions of law. We're merely setting forth our position.
Well, and what it made me think of when I was looking at this was Ms. Smith is a competent witness, but I've always thought she was presented as a lay witness, that she's never been qualified as a legal expert, nor Mr. Snyder as a legal expert when they present their testimony. Is that something you're planning on doing that you haven't done before?
No, if the chair would like, we'll qualify Ms. Smith as an expert in regulatory and policy. And Mr. Snyder, again, doesn't offer legal conclusions. He asks the commission to do something. So his aren't questions. And if he needs to be qualified as an expert in IRP modeling or what have you, happy to do so. But he's also allowed to rely on other things to which ORS is not objected, like the South Carolina chapter, for instance, which otherwise might be hearsay, to render his opinions as an expert.
Okay, thank you. Any other parties wish to be heard on this matter? Is there a reply from ORS?
Yes, briefly. Thank you, Chair Powers. Well, I understand Mr. Trewick's points, and I would invite you all to take a look at the various portions of Mr. Salter's testimony and the IRP report. And I think if you look at those and you compare those to the language used by Ms. Smith, I think there is a difference in the tone. I know that he cited one portion that we're seeking to strike. I would just point to another here. But where the foundational premises of the decision-making leading to an IRP remain unchanged, it stands to reason that the resource development activities that the utility undertakes should be informed by and in most cases align with the IRPs approved by our regulators. In the company's view, approval of an IRP should have meaning, and matters that should have been litigated or raised in an IRP should not be relitigated in future procurement, citing, or rate proceedings unless this is a change in circumstance from the date the IRP order is issued that warrant such issues to be revisited. That's on page 47 of Heather Shirley Smith's rebuttal. I would then, this is also page 54. Talking about approval. No, but I do believe approval of an IRP inclusive of a near-term action plan does change the evidentiary considerations and serve to streamline future proceedings for the commission and parties. It would be fundamentally unfair to completely relitigate, for example, whether a generating plant was reasonable and prudent to consider in advance if it was included in a resource plan that was deemed reasonable and prudent at the time it was considered, and no significant change in circumstance occurred that warranted a different course of action. And, in fact, other proceedings rely upon the Commission's IRP orders as key inputs. Those sound like legal briefings to me, respectfully. This is something that we believe goes beyond simply articulating an understanding of what the law currently is, what the regulation currently is. This is asking the commission to adopt a understanding of the law and to have ramifications down the road based on that ruling. This is, in ORS's opinion, this is legally conclusive, similar to the type of testimony that was pushed forward by the expert in Dawkins, and that it's clearly inadmissible under South Carolina law. We could go through every single one if that would be helpful to the commission, but I think if you go and visit them and you compare to the portions that Mr. Trawick has also identified, I think that you could see that there is a difference. Thank you.
Thank you very much. Again, this is a tough one. I think we've seen the testimony. It's pre-filed. I mean, this is different than a regular court when you apply the rules of civil procedure. But I think it would be best at this point. We're able to disregard what's necessary when we make our decision, and I think the best thing at this point, and not to belabor anything, or certainly don't have a position at this point, would be to take it under advisement, and we'll rule in our final order. But again, you understand my thoughts as a lawyer.
Thank you, Mr. Chairman.
Thank you.
Thank you, Chair Powers.
Thank you. The next thing, I think ORS has another motion for declaratory judgment.
Yes, thank you, Mr. Chairman.
Mr. Torrey, you have the floor.
Good morning, Mr. Chairman, Mr. Vice Chairman, and Commissioners. In this IRP proceeding, the companies are seeking affirmative relief from this commission that goes well beyond the purview and scope of an integrated resource plan in this state. Based upon their responsive brief, it's plain the companies prefer that no, or at least very limited, reference to North Carolina law is made in this proceeding. But North Carolina law is where we must begin to truly understand what the companies seek from the commission in this case. As the commission may be aware, in 2021, the North Carolina General Assembly enacted House Bill 951, which is called the Carbon Plan Statute. I've got it here on the Elmo, if we could show it just for your reference. Through HB 951, the North Carolina General Assembly sent a clear and singular mandate to your counterpart in North Carolina, the North Carolina Utilities Commission. Under HB 951, the North Carolina Utilities Commission, quote, shall take all reasonable steps to achieve a 70% reduction in emissions of carbon dioxide emitted in the state from electric generating facilities owned and operated by electric public utilities from 2005 levels by the year 2030 and carbon neutrality by the year 2050. HB 951 went further and required your counterparts in North Carolina to develop a plan no later than December 31st, 2022, with the electric public utilities, including stakeholder input, for the utilities to achieve the authorized reduction goals, which may, at minimum, consider power generation, transmission and distribution, grid modernization, storage, energy efficiency measures, demand-side management, and the latest technological breakthroughs to achieve the least cost pathway consistent with this section to achieve compliance with the authorized carbon reduction goals, which the statute refers to as the carbon plan. HB 951 further requires your counterparts in North Carolina to review the carbon plan every 2 years and, quote, make adjustments as necessary in the determination of the commission and the electric public utilities. North Carolina HB 951 places the carbon dioxide reduction mandate squarely on the shoulders of the North Carolina Commission. And that singular goal controls every aspect of integrated resource planning in North Carolina. If there was any doubt that the carbon plan controls resource planning in North Carolina, one need only look to the North Carolina Commission's initial carbon plan order, in which the North Carolina Commission held, quote, "For regulatory efficiency, the Commission deems it reasonable and necessary to consolidate its IRP planning functions pursuant to North Carolina General Statute Section 62-110.1c and its carbon plan development and execution oversight functions pursuant to the carbon plan statute." Execution oversight function. Resource planning in North Carolina is actually no longer about long-term planning. The legacy IRP rules have been subsumed by the carbon plan. The focus of the North Carolina Commission, rather than long-term resource planning, is instead to approve, 1, reasonable steps that, 2, the companies are authorized to pursue in the near term, 3, to execute the Commission's carbon plan. Okay, so under North Carolina law, the North Carolina Commission approves reasonable steps that the companies are authorized to take in the near term. And the near term in North Carolina is 2 years because the NCUC has to review a carbon plan every 2 years. So why should that concern this commission? Because of the following. This is page 8 of ORS's motion. And I'd like to read to you the first indented quote there, which is from the company's petition for approval of their second carbon plan that was filed with the North Carolina Commission earlier this year. This is a docket that's pending before your counterparts right now. Therein, the companies state, "In adopting the initial carbon plan, the Commission recognized the significant commitments and investments that would be required by the companies to develop major capital-intensive and longer lead time resources that are currently projected to be needed to achieve the state's objectives. To that end, the carbon plan order determined that it was reasonable and within the Commission's authority to pre-approve the company's decision to incur initial project development costs for purposes of carbon plan execution and to provide, quote, reasonable assurance of recoverability in a future cost proceeding, even if the resource is ultimately not selected by the Commission for the carbon plan." In other words, Commissioners, execution in North Carolina is accompanied by pre-approval of the initial project development cost and reasonable assurance of recoverability of the company's resource development costs in a future rate case. And that is even if the resource is ultimately not selected by the North Carolina Commission for the carbon plan. Now, in light of the express approval of the North Carolina Utilities Commission for the companies to incur significant, quote, initial project development costs, close quote, for purposes of carbon plan execution, and the request from the companies in this case, and actually a good example of it's right here. As Mr. Trawick noted and Mr. Welborn put up, this is an excerpt from company witness Heather Shirley Smith's rebuttal testimony. The companies are simply asking the Commission for determination that its 15-year proposed plan, P3 fall base, which includes the NTAP. NTAP meaning Near-Term Action Plan. It's what they intend to do from 2023 to 2026. For years 1 through 3 is reasonable and prudent, in the public interest, and consistent with South Carolina law and policy. In light of that language, which I suppose could mean a number of things, ORS felt compelled to file its motion. The ORS motion,
Mr. Torrey,
yes,
would it be fair to say that South Carolina does not have a carbon plan?
that is correct, sir.
Would it be fair to say we don't have the requirements that you put forth with the North Carolina laws?
That is absolutely correct.
So it's also fair to say that it puts the company in a pretty tough position to serve two states under two different laws. Is that correct?
It certainly does, but that doesn't mean that y'all need to bend over backwards for them.
And as far as this commission, in this case, is controlled by South Carolina law,
Yes,
and we've got to decide it or adjudicate it under South Carolina law.
that's absolutely correct.
And the matters in North Carolina, are we even able to consider their requirements?
You shouldn't consider their requirements, Mr. Chairman, because no South Carolinian had anything to do with the fact that the North Carolina General Assembly passed the carbon plan statute.
Okay. Who's up? And Ms. Traywick, if you'd address those same questions in your presentation, however you want to do it.
I'll be glad to, Mr. Chairman. I'll start with the fact that we can stipulate that North Carolina law doesn't apply here. I think my distinguished colleague on the other side referenced North Carolina, the North Carolina Utilities Commission or carbon plan some 40 times. But I'd like to recenter our focus, if I might, back to South Carolina. In South Carolina, we have a statute that sets forth balancing factors. And the commission must decide what is the most reasonable and prudent plan at the time the plan is reviewed. And that's all we're asking for. So you've heard from Mr. Torrey what ORS believes the companies are asking for, but that's what the gloss ORS adds to our request. I think it's better that you hear it from the horse's mouth. So let me start there. We are not asking you to approve a nuclear plant or Bad Creek 2 or our solar procurement in this proceeding. We'll have proceedings later on that. This isn't the big scary. This is what we do seek from the commission. In a word, clarity. The companies are not seeking pre-approval of costs. The companies are not seeking assurance of cost recovery. The companies are not asking the commission to make a premature determination on matters covered in Siting Act proceedings, base rate cases, fuel cases, or the like. And the companies are not asking the commission to tie parties' hands behind their backs in future proceedings on whether we reasonably and prudently executed on our IRP, including the near-term action plan. The companies do, however, seek the same thing that Dominion and Santee Cooper got in their IRP cases for South Carolina customers. And that's a finding that their near-term action plan is a reasonable and appropriate guide for generation and transmission planning activities. That's it. The companies do seek clarity on which resources the commission believes are best for South Carolina so that we can plan, invest, and execute on them to reliably serve the needs of South Carolina customers. The companies do seek clarity that the IRP process actually means something and isn't just window dressing. The companies do seek meaningful information and participation from all parties. And what that means is that parties don't keep their cards close to their chest and then ambush us in a rate case with an argument that should have been raised here and should have been raised now. And so basically the companies seek clarity that the commission's ruling in an IRP proceeding is worth more than the paper it's written on. And ORS, however, demands a presumption of bad faith before you even hear testimony from witnesses Glenn Snyder and Heather Shirley Smith, for example, on how the plan was created. Respectfully, that is inconsistent with the regulatory construct in South Carolina. What the companies seek, on the other hand, is entirely consistent with the IRP statute, the Commission's prior orders for our IRPs and other utilities, traditional rate-making principles, and the South Carolina regulatory construct as a whole. We seek approval of P3 fall base as the most reasonable and prudent plan at this time, and we seek for the Commission to find our near-term action plan as reasonable and appropriate guide for generation and transmission planning. Now, I do want to zoom into some of the more specific legal arguments that ORS has made here. First of all, regardless of the title, we think this motion is a backdoor attempt at a motion for summary judgment. But the Commission hasn't established procedures for deciding a motion for summary judgment, such as, for example, Rule 56 of the South Carolina Rules of Civil Procedure. And so it's really improper under the Southern Bell case we cited in our brief and under the Commission's regulations for the Commission to be citing issues before evidence is received into the record. So we respectfully take issue with that from a procedural aspect because no regulation was promulgated pursuant to the Administrative Procedures Act. And under the McIntyre case, the Securities Commissioner of South Carolina, that is reversible error. It's a violation of due process that cannot be deemed harmless. And so for those reasons, we think it's not procedurally proper. Now turning to the first two questions on which ORS seeks a declaratory judgment. Again, we haven't sought pre-approval. We haven't sought assurance of cost recovery. So therefore, there's no justiciable controversy. So to the extent this matter is properly before the Commission isn't here to tame paper tigers or decide issues that are not subject to a genuine concrete dispute. And that's exactly what Justice Hill said in the Alterna tax case. So because there's no actual controversy on the first two, we don't need an advisory opinion from the Commission on those issues. And in fact, there's case law from the Supreme Court of South Carolina indicating that that's inappropriate. Now let's get to question 3. That's the meat of the case. The Commission has recognized that the IRP process post-Act 62 significantly strengthened the IRP process in South Carolina, signaled the heightened importance of the IRP process and the critical role assigned to the Commission, and that's from Order 2021-246. Yet ORS seeks to downplay the importance of this proceeding, all in derogation of the General Assembly's mandates and this Commission's prior orders. The outcome of this proceeding, however, is used in other places, as we well know. IRPs are relevant to avoided costs, CPREs, Siting Act applications, and rate cases. After all, we're on a continuum: plan, execute, and recover. Before Act 62, the Commission didn't have such forward-looking authority, but Act 62 gave this process teeth, and it gave the Commission the authority to rule on IRPs to determine what's the most reasonable and prudent plan at this time for customers of South Carolina. As part of that, the Commission has been approving or finding reasonable and appropriate near-term action plans. And so that's what we're seeking. Now, the rub here centers on subsection 583740C4. And really the phrase shall not be determinative. We all agree that a ruling in this proceeding shall not be determinative of a future rate case, for example. That doesn't mean it isn't relevant. And that also doesn't mean that it's not informative to utilities as we make plans and execute on those plans for the benefit of our customers. So although we agree that not determinative means not determinative, the logical extension of ORS's argument is that it means nothing. Well, if that's the case, then we're all dressed up with nowhere to go here. And that can't be what the General Assembly intended. You've got to read the statute in a way that accords with the General Assembly's intent, the general purpose of the statute, and doesn't lead to an absurd result. In our last IRP, the Commission observed that Duke will make a variety of resource decisions over both the short term and long term. Those decisions, though they could change over time, should be reflected in Duke's preferred portfolio. Further, Duke's IRP will serve as an input in a variety of other proceedings. Those inputs vary depending on which portfolio is at issue. We agree. It's relevant. It is important to future proceedings. And on that note, I have to say, ORS's motion is incongruous in the argument versus the relief it seeks. ORS spends all its time arguing on what North Carolina is to then get a declaratory judgment on what South Carolina means, South Carolina law means. It makes no sense. This was merely a tactic to inject North Carolina law and get the temperature up in the room before we even started this proceeding. Respectfully, that's not appropriate. The companies merely seek what Dominion and Santee Cooper received And having clarity that we are on the right track is important for the companies, our customers, prospective customers, our investors, and other stakeholders who are present in the hearing room. What's more, it's entirely consistent with the text and the purpose of the IRP statute. And so the last I'll just finish with, the IRP has to mean something, right? But if facts and circumstances change from the date this order is issued, we're on the hook. If we do not execute prudently and reasonably on the plans that this commission approves, that is certainly fair game in a future proceeding, and we don't argue to the contrary. But if, for example, ORS is going to say offshore wind is not right for South Carolina because it's just to comply with North Carolina law, if that's the argument, that argument needs to be made here and now, not in a future rate case where we've already spent money and the horse is out the barn and down the road. That's not appropriate. It's also not consistent with the public interest. The public interest, in fact, is in subsection G of the balancing factors of what the commission has to decide. ORS statutorily represents the public interest. So how would them being quiet in this proceeding advance that interest? In our view, it wouldn't. And so for these reasons, Ms. Smith spends 26 pages of her direct testimony explaining how the companies complied with the commission's mandate last time. Y'all gave us homework and said, you're in a dual state system, and when those principles don't align, it's got to give way to South Carolina law. And as our witnesses will show, and they're eager to speak with you, we viewed this from a South Carolina lens and have set forth testimony showing how this is the best plan for South Carolina, notwithstanding all the references to North Carolina we've heard this morning. So it is through that framework that the commission should decide this, and the commission should reject ORS's motion and its position on the import of the IRP process. Happy to answer any questions.
All right. Commissioner Belser.
Good morning, Mr. Trawick and all in attendance. I don't want to get off on a rabbit trail here, but I do recognize that a number of years ago, I think it was 2011, 2012, the commission approved a joint dispatch agreement. I think it came about at the time of the Duke Carolinas and the Progress Energy merger. And Mr. Trawick, you may not be able to speak to this, but I'm just putting this out there. And I think there was some later amendments to that order that gave Duke Energy Carolinas kind of a management role over some of the contracting, maybe for gas or fuel or things like that. I guess my concern is how does the joint dispatch agreement and those subsequent orders impact the planning put on that Duke has to undergo, since it is a dual state system? And if you can't answer, that's fine, but I just think that that's something that needs to come out somehow in this proceeding.
Commissioner Belser, as you may recall, I think I might have been a law clerk at the Office of Regulatory Staff at that year, but so I don't have any firsthand knowledge of it, but I can tell you who does, and that's Laura Bateman, and she'll be here to testify before the commission.
Okay, thank you very much. I just think that that's an element that needs to come out with regard to the planning that goes into the IRP.
Certainly.
Thank you.
Appreciate it.
Thank you, Commissioner Belser.
Mr. Chair.
Mr. Trawick.
Mr. Chair, if you don't
Vice
mind,
Chair Williams.
I have I guess a clarifying question.
Help yourself.
Maybe. Mr. Trawick, I hear you loud and clear regarding the company seeking clarity that an IRP has meaning and the IRP must mean something. So with that statement, it leads me to believe that right now the company doesn't know the meaning of an IRP in South Carolina. I'm a little confused.
No, with respect, Vice Chair Williams, we do have a clarity on what the law means. We need clarity from the commission on what it wants us to do, right? And that's sort of the purpose of the IRP. We're not asking for cost recovery, and that's what all of the questions for declaratory judgment center on. We want clarity from the commission on this being the most reasonable and prudent plan at this time, and that the near-term action plan represents a reasonable and appropriate means for transmission and generation planning. And so that's all we seek, and we think that's pretty crystal clear in South Carolina law. ORS has sort of injected the confusion in this proceeding by filing this motion and not taking positions on key issues.
Understood. Thank you, Mr. Chair.
Thank you, Vice Chair. Commissioner Caston?
Good morning, Mr. Trawick.
Good morning.
I want to make sure I understood, and I don't want to put words in your mouth relative to the IRP. I don't think you said it this way, but like, is the company's argument, are you saying the company's argument is that a rate case, I guess issues that might come up in a rate case should be argued in the IRP?
No, that's not what we're arguing at all, Commissioner Caston.
We're saying,
sorry.
I'm glad I asked.
That's right. No, that's not our position at all. What we're saying is that we want you to make the decision that the General Assembly set forth by statute, and ORS seeks to downplay the import of that decision by saying not determinative essentially means, under their view, as I see it, not relevant at all. But that's not the case. We've had proceedings in which the Commission has, at least in part, relied on IRPs to make subsequent decisions.
So the company's asked us to comply with South Carolina law.
Bingo.
Good enough. Thank you.
Thank you.
Thank you, Commissioner Caston.
Mr. Chairman, if I may, just very brief reply.
Certainly.
Mr. Trawick said the company, quote, they plan, they execute, and they recover. So what I've got here is a chart. This is in the motion, page 10, the column to the far right. Excuse me, it's the resource plans that the company has proposed for to incur initial development costs for long lead time resources. And it's proposed the same thing in North Carolina as here. The megawatts are the same, the resources are the same. The only thing you see different is dollar signs. And you see dollar signs under the North Carolina column because they have received pre-approval to incur project development costs up to those amounts. Mr. Trawick said if facts and circumstances change, we're on the hook, i.e. the company's on the hook. Okay, what's the inverse of that? If facts and circumstances don't change, the ratepayers are on the hook. They're asking you in this proceeding I know Mr. Trawick says they're not asking you to prove a nuclear plant. I don't know what they're asking then, because they're asking, they want to spend $440 million over the next 3 years to do not research and development, licensing, contracting with for long-term lead resources. If SMRs is in this IRP and the commission approves it as part of the near-term action plan under the company's expressed intent, unless something changes, South Carolina ratepayers will be on the hook for SMRs. Thank you.
Thank you. Mr. Trawick, just a couple things. You used the word mandate as far as an IRP, that it needs to have some meat to it, I guess.
That's right, Mr. Chairman.
Isn't some of the issues in this case the fact that Duke hasn't complied with earlier IRP?
I respectfully take issue with that. Those witnesses will be able to speak to that later, and to the extent you're mentioning modeling requests, and they can explain if that was the case, why.
So, and you're saying that in North Carolina, forget North Carolina.
I agree.
You're saying that the IRP will not eliminate the requirements that we have dealing with Siting Act cases and other cases that you're not asking us to pre-approve expenses, declare something reasonable and prudent before we deal with it or hear about it, or before it even exists?
Not at all.
Okay. All right. Okay. Well,
Chair Powers, could I ask for a follow-up question?
Sure, Commissioner Williams.
Thank you. I really wanted to ask Mr. Torrey if you would follow up on what Mr. Trawick said with regard to ORS not taking positions on key issues.
I think Mr. Trawick's position is that, and it's laid bare by the testimony of company witness Smith, that the company is the company wishes that ORS would litigate the merits of the company building such nascent resources as small modular reactors and offshore wind in this IRP proceeding, when there's not a single operating SMR in the United States. Cost estimates, we don't know. We don't know where this is going to be, but we should have done more work. We should have really litigated whether whether South Carolina ratepayers should have SMRs or not. And frankly, Commissioner, I don't know how we're supposed to do that.
Because of lack of information.
Correct. I mean, Commissioner, just think about what information comes before you in a Siting Act case. It's where is it? What's the environmental impact? How much is it going to cost? We don't know those things.
Thank you. Thank you, Chair Powers.
Thank you.
Chair
Commissioner
Powers.
Thomas.
Thank you. I'm a little confused. So, Mr. Trawick, you listed quite a few things that you said that the company is not asking for approval of, such as spending money on Bad Creek and nuclear and so on and so forth. And then you turned around and you said, but we need to know now whether offshore wind in North Carolina is appropriate for South Carolina. I'm having a hard time reconciling those two statements. Can you help me out a little bit?
Sure. One deals with cost recovery, and one is a decision on whether to pursue the resource. And, to the extent Mr. Torrey said ORS had questions, we've had an abundance of discovery here. We've got experts coming up to testify, and you can ask Mr. Capps all that about SMRs and on cross-examination. That's fair game. I disagree that those are the same. We're asking whether you think it would be a good idea to move forward on it. We're not seeking recovery of those costs, but if you have concerns and think that the companies are simply pursuing offshore wind because of North Carolina law, which seems to be what they're implying but not outright saying, then I think we want direction on that in the order. And I don't think that is incongruous with the statute at all. And if I might, I would like to respond to Commissioner Williams' question to Mr. Torrey to offer my perspective on that.
Well, I had a little follow-up here myself first, please. So, again, I heard you say that we are not asking for approval of cost recovery for Bad Creek and so on and so forth. And so another thought that I have is what you're saying is that sworn testimony that we can use in an order, or do we need to hear that from witnesses that are sworn in?
That's a legal argument. So there's a prohibition, as I cited in response to our motion to strike, against the lawyer witness rule. I'm not acting as a witness, but I do owe a duty of candor toward the tribunal. And so I'm telling you, as counsel for the companies, we are not seeking cost recovery for any specific resource at this time. That was a petition filed in North Carolina that doesn't have a thing to do with South Carolina law.
All right. So I think what I heard you just now say is we need to hear that from a sworn witness.
And they'll verify what I just said as counsel for the companies.
Thank you. That's all I have.
Mr. Chairman, may I follow up on that?
Certainly.
Mr. Trawick, you're not a witness, but as you stated, you have a duty of candor to the tribunal.
Right.
And an attorney can be viewed as an alter ego of the client.
Well, agent, not alter ego. Alter ego gets into some business law.
There's a case law. That's from a case site.
Agent, though, not alter ego. Sorry, I've been dealing with that in the asbestos docket, and that is
I understand, but there's a South Carolina case that says alter ego of the client. But we can count on your representation as an officer of this court of what you just said. Is that correct?
That we are not in this proceeding seeking cost recovery.
I just want everybody to understand that your council, you have a duty of candor to this tribunal, and we can count on your words as being truthful.
Of course.
Yes.
And I'm saying we are not seeking in this
And
proceeding.
I'm not disputing that. I'm just trying to explain what your words mean, even though you're not a witness.
Understood. And I try to explain that nuance, perhaps not in the clearest ways. Thank you for keeping me straight.
Thank you.
Thank you, Commissioner Belser.
If I may respond to Commissioner Carolee Williams,
Certainly.
Mr. Chairman. Thank you. So in terms of relevant positions, Commissioner Williams, I don't see once in ORS's testimony whether P3 fall base or any other portfolio for that matter represents the most reasonable or prudent plan for customers at this time, or whether it doesn't. I also don't see any testimony controverting Duke's undisputed testimony that our plan and our recommended portfolio complies with South Carolina law. Instead, they focus on North Carolina law and seemingly foreclose the possibility that just because something complies with North Carolina law, it can't comply with South Carolina law. Well, two things can be true at once, and even if ORS arbitrarily views it that way, the Commission shouldn't, and we'll have testimony showing exactly why our plan marries the interests of both states. Thank you.
Mr. Trawick, anything else you'd like to say before we go to other parties?
Appreciate the Commission's time and attention to these matters.
Okay.
Thank you.
Any other parties wish to be heard?
SACE and all, we filed very brief comments on the motion for declaratory judgment. I'm happy to share those if that would be helpful.
Okay.
I can do. Is it okay if I do that from here? Or
One of you fellas move over. We keep this up, we may not have to take testimony. Who knows?
Thank you, Chair Powers. Kate Mixon on behalf of SACE CCL, Upstate Forever, and Vote Solar. As we noted in our response letter filed on the 11th, we don't disagree with any of the four statements that were made in ORS's request for relief. To us, those are very clear and indisputable South Carolina law. Act 62 clearly states that approval of any action in an IRP is not determinative of the reasonableness or prudence of that action, which is required for cost recovery. But we also believe the Commission has an obligation to review and approve, modify, or deny a utility's proposed IRP, which must include its plans for meeting both current and future capacity needs, and therefore it has to implicate both near and longer term actions. IRPs clearly are not intended to supplant later cost recovery or citing proceedings, but to Mr. Traworth's comments earlier, we are here for a reason this week, in that IRPs are serious planning exercises, and we believe the Commission clearly has the authority to provide direction to utilities regarding those near and long-term actions. To our knowledge and belief, Duke has not requested pre-approval of any costs in this proceeding, and is asking for direction from the Commission regarding the substance of their plan. We obviously disagree with the companies in several respects about whether their preferred plan is the best path forward, but likewise would like to focus on the merits of the IRP and whether it is the most reasonable and prudent plan for the utilities. And so again, because we don't believe the issues raised in the motion are in controversy, CCL and all do not believe that ORS's request for relief is necessary at this time. Thank you.
Thank you, Ms. Mixon. Anyone else? Does ORS?
Mr. Chair, may I ask Ms. Mixon a question?
Yes, Vice
Simple
Chair.
question. Ms. Mixon, thank you for your comments. Based on your involvement in the IRP process in South Carolina, have you at any time before today felt there was a lack of meaning or direction coming from the Commission and its IRP proceedings? Because I'm hearing a lot of that today, and I'm just trying to understand where that's coming from. And since you're in the middle, I think you may be able to offer some insight. Thank you.
Thank you, Vice Chair Williams. I'll say no to this point. I don't think that it has been
been unclear. Our understanding to this point is and has been that the purpose of an IRP is for the commission to review what the utilities plan is, again, over both the short and long term. That plan will obviously include different actions that are at different levels of specificity. The closer you are in time, the more specific information can be included in an IRP, and the further out you are, things may be more generic. But it is really the intent to provide kind of a snapshot in time where the commission can say, all right, at this point, this range of actions appears reasonable, but at a later point in time, through another proceeding, the specific actions that a utility has taken in accordance with that general plan would be reviewable. So, for example, if if there was an action that was approved in a near-term action plan, the utility took that action, but maybe they overspent, those would be actions that could be reviewed as part of a rate case and may result in a disallowance. Or as another example, if your circumstances changed and actions that were in an approved IRP were no longer prudent at a later point in time, that would also be reviewable and again may result in a disallowance. And so I don't think that it has been, I don't think that it has been unclear kind of what the purpose is. It is to provide direction, ensure that there are not surprises to the commission or other parties regarding resource actions that a utility takes. But again, it doesn't mean that actions that are in an IRP are not reviewable at separate points in time. And I think Act 62 makes that clear.
Thank you, Vice Chair. Anyone else? ORS, you are allowed to apply if you
Mr.
like.
Chairman. Mr. Chairman,
Mr.
this is
Burns.
John Burns. Thank you. I'm sorry to be remote on this, but I did want to note that CCBA also submitted comments in writing, and just wanted to echo those. We are fundamentally, I think, in agreement with the perspective Ms. Mixon just enunciated. We believe that ORS's motion would essentially obviate the meaning of the IRP process, that the IRP does mean something. To respond to Commissioner Justin Williams's question, and it has meant things. It has meant that you make a determination as to the reasonableness and prudence of the utilities' plans for the coming years. And we take part in that process as interveners because of the importance of that determination. It is the nature of the industry and the nature of utility planning that it takes time, and it must be done over longer periods of time. And thus that your determination is helpful to telling the utility and those of us who contract with utilities what is deemed to be a reasonable and prudent course of action, or the most reasonable and prudent course of action. I would also note that I represent CCBA in both North and South Carolina, and I have been before you in prior IRP proceedings for these companies. And the determination that you have to make under Act 62 is not changed by North Carolina's passage of House Bill 951. So we would say that we would ask you to overrule or to deny the motion from ORS and to proceed under Act 62, which is pretty clear as to what needs to be considered and determined and the effect of that determination.
Thank you, Mr.
That's all. Thank
Burns. And please speak up whenever, because I'll forget about you.
That happens a lot.
You want to speak, Mr. Toy?
Thank you, Mr. Chairman. And very, very briefly, just really want to put a bow on this, and I'm just going to read the statute. 5837 C, subsection 4. The submission, review, and acceptance of an integrated resource plan by the Commission, or the inclusion of any specific resource or experience in an accepted integrated resource plan, shall not be determinative of the reasonableness or prudence of the acquisition or construction of any resource or the making of any expenditure. Any electrical utility shall retain the burden of proof to show that all of its investments and expenditures are reasonable and prudent when seeking cost recovery in these rates. And I'm sure you'll hear argument throughout this case, commissioners, about what that statute means. I think both the briefing, both the companies and the ORS said statute says what it says. So I guess we'll just find out what it means.
Thank you, Mr. Torrey. Anything further from any party? All right. Here's what we're going to do. There's so much to this. I am going to take that, or the commission's going to take that under advisement and issue it in our final ruling. Here's the other thing we're going to do. I want to instruct everybody that this case is controlled by and must be adjudicated under South Carolina law. If there's any relief requested that exceeds the commission's statutory authority or runs afoul of provision of the IRP statute, that cannot be granted. Number two, in allowing witnesses to separate their testimony and to come down and talk to their attorneys or talk to other parties, we are asking the lawyers under their duty as attorneys, no coaching. We want to stick with the issues. We have pre-filed testimony. We know what everybody's saying, and we want to stick to it. We got a lot of ground to cover, and I don't want this to become just a continuing argument between the parties. Again, we are reserving the right to question before or after rebuttal or before or after rebuttal, and commissioners may ask questions at any time, even though they may not direct them when you normally would expect them. We may not ask questions on direct. We may wait and ask those questions afterwards, and we're holding on to that. Is there any other issues that, well, there are two more. We have 3 witness conflicts, or as you have 2 that need protection. I'm not looking at the calendar, September
Yes.
24th, 25th, and 27th.
And that's for Mr. Hayat and the 27th for Ms. Wellborn.
Okay. Well, we'll work around that the best we can.
Chair Powers.
Yes.
I apologize for interrupting. On that note, the companies also have a variety of conflicts based on hearings in other states and other sort of personal witness issues. We've discussed that with counsel for the other parties, but would be glad to file a formal request with this commission for folks' awareness in case we need to move a witness up or back in the witness order, if that pleases the chair.
Okay. Well, just let us know what you need and when.
Thank you, sir.
All right. We also usually give the opportunity for opening statements or closing statements. And would the parties want to proceed with that or not?
Chair Powers.
Yes, sir.
Richard Witt for SECIBA. We have a written request we filed earlier in September for witness Haggerty to have his date certain of the 19th in a panel with Hamilton Davis, and he's out of state. So we just wanted to confirm if he has that date certain on the 19th.
You're right, and I overlooked that on my note. Yeah, certainly.
All right. Thank you, Mr. Chairman.
Thank you, Mr. Witt.
Chair Powers.
Commissioner Thomas.
Thank you. Given that we're going to have direct testimony and then rebuttal testimony, I would like for each witness, once they're sworn in, to say whether or not they are going to be back. I don't want to have to guess who's coming back. I want to know up front, as soon as you're sworn in, whether you're going to be coming back. That would be helpful to me. I would appreciate that if we can do that.
Certainly, and we may be able to provide some sort of list as to how that's going to work or who's going to testify when for the commissioners. Back to the opening statements.
Yes, sir. I do have an opening statement for the companies.
You got it. After all that work, I know you want to talk.
Let's try that again. Good morning, Chair Powers, Commissioners. Thank you for your time this morning. Duke Energy Carolinas and Duke Energy Progress are pleased to be with you this morning to present our plans to serve South Carolina's energy future and to explain how the company's resource plan meets the balancing factors of the South Carolina IRP statute. IRP proceedings can be complicated. There are any number of complex issues that we can and likely will talk about throughout the course of this hearing. But the General Assembly has put before this commission a single question. Is the company's IRP the most reasonable and prudent plan at the time it's reviewed? In answering that question, the law instructs the commission to consider 7 balancing factors. And there are also other sources of South Carolina law and policy that we believe are important to consider, and those are provided in the South Carolina chapter of the IRP. This hearing is the culmination of a lot of work on part of the companies and other parties. We started stakeholder engagement over 18 months ago in February of 2023, holding a series of sessions with other parties and gaining valuable feedback. We filed the IRP over a year ago in August of 2023, and as y'all know, we were compelled to supplement the IRP based upon dramatic load growth that we were experiencing in our service territory and the need to plan for more generation to meet this increased projected load. From the start of this case, we've completed 338 modeling runs throughout this proceeding and put forth 53 different portfolios in response to prior commission orders and stakeholder feedback. And we put forth a recommended portfolio, P3 fall base, that balances those IRP statutory factors. We will put forth a strong case, in my opinion, in favor of our recommended portfolio, P3 fall base, focusing on South Carolina law and policy and the needs of our South Carolina customers. In contrast, no other party has proffered an alternative recommended portfolio for the Commission's consideration, and they could have. We provided our modeling files and data and input assumptions over a year ago, last August, and no other party either conducted modeling of their own, or if they did conduct their own modeling, they did not file it with this Commission. Further, not only did no other party put forth an alternative portfolio, they advocate for positions that would fail to balance the IRP statute's factors or would result in portfolios that are not executable. Because of the dramatic load growth that we're seeing, this is a critically important time to confirm that we're planning for the right resources and that we're on the right track. Put simply, we need to get moving on new generation to replace aging resources and meet new load. We have a near-term action plan in our IRP that reflects our proposed activities to get new and diverse resources on the system, and it covers the 3 years between the IRP planning cycles in South Carolina. In the longer term, in the back half of the 15-year planning period, there are new types of resources, some of which we're further evaluating, but continuing to progress so that they remain an option to us. South Carolina customers have benefited from the company's diverse generation portfolio for over 100 years. Our long lead actions are designed to provide options for continued resource diversity into the future. These long lead resources, such as offshore wind, are not locked in at this point. We're proposing an acquisition RFI to obtain more information about the cost of offshore wind. We've made good progress on evaluating Bad Creek 2, and those evaluations remain ongoing. Assuming we remain on track, we have plans to file a siting application before this Commission next year as shown in our near-term action plan. For other long lead resources, we have to start today to even get them on the map. One example is our plans to advance new nuclear at our existing coal site. That's a process that has to start now for it to even be a possibility. We will continue to plan and be able to check and adjust in the next IRP proceeding based upon new and updated information. All of these longer-term options and many of the shorter-term options will come back before this Commission in other proceedings, such as in the CPRE dockets, in Siting Act proceedings, and in future IRPs and IRP updates. So this is not a one-and-done exercise. But we're here today because the statute demands that the Commission evaluate the company's resource plan and tell us whether it's the most reasonable and prudent plan for South Carolina's energy needs. This is a critical step in the process. We need to know that we're on the right track for what we're planning to do tomorrow and over the next few years. Earlier this year, the Commission found for both Dominion and Santee Cooper that their near-term action plans were reasonable and appropriate as guides for their generation and transmission activities in the near term. Duke Energy needs its own Commission-approved guide as we look to execute on new resources to meet growing load in the Carolinas. As highlighted in Ms. Smith's testimony, South Carolina was the fastest growing state in 2023. We've got to look out for the needs of our current customers and meet the needs of these new customers while we execute on these new resources. Yes, we have to comply with applicable law. Yes, we need reliable power, but the companies are also always looking for ways to make it work for all of our customers. We're taking advantage of federal tax credits to keep costs down. We're using competitive practices, bidding out construction contracts, and competitively procuring renewable energy and capacity under South Carolina's CPRE statute. Importantly, we're looking to further diversify our resource portfolio consistent with the IRP statute that will further help mitigate risk for our customers. But we as a state need to take steps to meet the growing and changing energy needs of South Carolina. While we work on those next steps, we have to do so recognizing the changing landscape that's putting increasing pressure on these activities. Pressure on emissions, our aging coal fleet, the supply chains that we rely upon, and on our ability to execute while other utilities, including those in the state, are working through similar pressures. Our IRP stands strong when you compare it against South Carolina law, and I'm hoping that we can focus more on what South Carolina law and policy tell us than get bogged down or distracted by North Carolina law. As Ms. Smith states in her testimony, two things can be true at once. We can have a plan that works for both South Carolina law and policy and North Carolina law and policy. And Mr. Snyder and Mr. Quinto will be up soon to tell you how they put the plan together. So despite the complexity that other parties may attempt to inject into this proceeding, we're asking for two things from this commission, both of which squarely align with law and policy in prior commission orders. Number one, confirm that the diverse and balanced P3 fall-based portfolio represents the most reasonable and prudent plan for South Carolina. Number two, confirm that the company's near-term action plan, which represents the first 3 years of the IRP, is reasonable and appropriate as a guide for the company's generation and transmission planning activities. In closing, as our plan shows and our testimony this week will confirm, the companies are not asking for unique relief or trying to imprint North Carolina law on this commission's decision-making. Instead, we're asking for you to evaluate our resource plan and recommended portfolio against the 7 balancing factors provided in the IRP statute as informed by South Carolina law and policy. I'd like to leave y'all with where we began, a recent commission order in a prior IRP docket. This commission has said, quote, "It is incumbent upon the utilities to recognize that North Carolina and South Carolina have different statutory structures, which at times align. In other instances, however, due to specific regulatory requirements unique to a single state, dual state planning must accommodate those differences," end quote. Based on the motions that have been filed, y'all are probably going to hear more from other counsel about North Carolina law and North Carolina resource planning. Our task in this hearing is to identify the most reasonable and prudent plan for South Carolina that's real and executable. Parties can always throw darts and recommend new modeling, but we've been at this point, over 13 months in the hearing, which was also, again, preceded by stakeholder engagement. The companies will show throughout our case where the states align and how our dual state plan accommodates any differences. But it's important, as the commission has said, to look at both, and we've done that in this case. Thank you for your time. We look forward to putting our experts up here before you to ensure that your questions are fully answered so that you're ready to decide the important issues of this case. Thank you.
Thank you, Mr. Welborn. Interveners, Sierra Club. Ms. Jaffe, would you like to make a statement?
Good morning, Commission. Dorothy Jaffe on behalf of the Sierra Club. Just really quickly, the Sierra Club did file joint testimony of Mr. Goggin, Maria Rumpani, Mr. Turk, and Mr. Duncan, jointly with South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Upstate Forever, and Vote Solar. And you will be hearing from them in the coming, hopefully just week, but maybe weeks. But we would ask that the commission not approve Duke's portfolio P3 fall as it's currently written. We believe that the pathways are not a meaningful range of portfolios because they rely too heavily on gas. We still have some unanswered questions regarding the impacts of the new EPA rules, including the Section 111 rule or greenhouse gas rule, as you'll be hearing later on this week. We believe that the timing of the coal retirements are too closely related to the replacement of them with gas resources and should be more closely tied to the significant and substantial impacts of the new EPA rules, as those will have cost implications for customers. You will also hear from Mr. Goggins about how the IRP overstates the challenges associated with interconnecting renewables. And you will also hear from him that Duke assumes generic transmission network upgrade cost adders for both wind and solar that are too high and that fail to account for the benefits of those transmission upgrades. But you will also hear that the Sierra Club does support the Red Zone 2.0 projects. So we don't all, 100% disagree with everything that is coming out of the Duke IRP as it's currently proposed. But we do ask you to, pay attention to some of the direct testimony from Mr. Goggins and our other experts that are going to be here before you over the next couple of weeks, and to not approve the P3 fall base as currently proposed. Thank you.
Thank you, Ms. Jaffe. South Carolina Coastal Conservation League, SACE, Upstate Forever, and Vote Solar.
Thank you, Chair Powers. Just very, very briefly, we appreciate the opportunity to be here today and to present our case to the Commission. To add to Ms. Jaffe's statements, our experts conducted a close review of the company's methodologies and assumptions going into the IRP and raised a number of concerns that the company's preferred plan does not adequately manage future risks from fossil generation, shortchanges clean energy resources like solar and storage, including distributed resources, and as Ms. Jaffe stated, presented a number of opportunities for improvements to the company's transmission planning. Again, we look forward to presenting our case to the Commission, and thank you again for allowing us to be here.
Thank you, Ms. Mixon. Carolina's Clean Energy Business Association, Mr. Burns or Mr. Witt?
Mr. Chairman, SECIBA doesn't have an opening statement, but we also appreciate the opportunity to participate in this docket. Thank you.
Thank you very much. Walmart Inc.
Good morning. Again, Stephanie Eaton here on behalf of Walmart. Chair Powers and Commissioners, with 43 facilities located in the company's service territories, Walmart appreciates the opportunity to participate in this IRP proceeding and definitely believes that it has meaning for Duke's customers. Walmart does not fully support Duke's preferred portfolio P3 fall base, but does support the dual state system focused on a carbon neutral future. Walmart's aggressive renewable energy and sustainability goals, about which you will hear when Walmart's witness Lisa Perry testifies later in the hearing, combined with its operations in both states, are consistent with the adoption of a path forward that maintains alignment across both states. Walmart disagrees with Duke's request to increase winter planning reserve margin to 22%, but does support an increase to Duke's winter planning margin to no higher than 20% on a combined basis. We understand that Duke does plan to file an updated resource adequacy study that would be conducted before 2027, which is another thing that's important to Walmart. Finally, Walmart supports the requirements for the companies to continue collaboration with interested stakeholders to develop new and innovative solutions that leverage the customer's abilities and the customer's resources, such as Walmart, to reduce the need to build additional generating capacity expeditiously. Walmart supports the development of programs that support at least 600 megawatts of on-site generation through customer investment. And that is another thing that you will hear from more when Ms. Perry testifies. Thank you.
Thank you, Ms. Eaton. Office of Regulatory Staff. Ms. Rainey.
Good morning, Chair Powers, Vice Chair Williams, and members of the Commission. We are here today to discuss Duke Energy's Integrated Resource Plan that was filed for Commission approval some 398 days ago. We are not here to litigate a rate case, a siting application, competitive procurement for renewable energies, or any other cost recovery proceeding. An IRP is the electrical utilities opportunity to share with the Commission and interested parties how it plans to address its energy and capacity needs over the course of a 15-year period, and to determine whether the utility's preferred plan represents the most reasonable and prudent means to meet such needs at the time the plan is reviewed. This determination should be made on the plan as a whole rather than certain parts of that plan. Like most proceedings before the Commission, we will address very technical and complex information. However, 583740 outlines the requirements of an IRP. Notably, Section 40 is also instructive of what an IRP is not. 583740 C4 in its relevant parts state the submission, the review, and acceptance of an IRP by a commission or the inclusion of any specific resource or experience in an accepted IRP shall not be determinative of the reasonableness or prudence of the acquisition or construction of any resource or the making of any expenditure. The section also states an electrical utility shall retain the burden of proof to show that all of its investments and expenditures are reasonable and prudent when seeking cost recovery and rates. ORS therefore believes the Commission should limit its decision in this proceeding to whether the company's proposal represents the most reasonable and prudent plan to meet its energy and capacity needs over a 15-year period. And that's at the time the plan is reviewed. ORS reviewed Duke Energy's IRP in accordance with South Carolina law and federal law, particularly 583740, Commission orders, and the new EPA Clean Air Act 111 regulation. As you will hear from ORS's witnesses, Salter, Wellborn, and Hayet, ORS made 19 recommendations. And of those 19 recommendations, only 6 recommendations remain unresolved. Chair Powers, Vice Chair Williams, and members of the Commission, ORS requests that you accept and approve ORS's recommendations as outlined in its testimony, its report, and as further explained throughout this hearing. Thank you.
Thank you, Ms. Rainey. We've been going for some time now and hadn't even started. I think we're going to take about a 15-minute break, come back at 11:45. I was thinking we would probably have lunch around 1 or so, if that suits everyone. I would like the rest of the week, we got a lot of ground to cover. You brought all these people up here. Maybe start at 9:30 if that works, and maybe run till about 6. I don't know, today we'll stop a little earlier than that, maybe 5:30, 5 or 5:30, depending on where we are. On Friday, we will adjourn about 3 o'clock. So I tell you that early in case anyone has weekend plans of any sort. And we'll just go from there. I hope things move quickly and everybody gets a chance to be heard. And Just be back at 11:45. Thank you. We are now back on the record on the Duke Energy's IRPs 2023-8E and 2023-10E. We are ready now to proceed with the testimony, and we'll turn it over to the company.
Thank you, Mr. Chair. The companies would call Ms. Heather Shirley Smith and Glenn Snyder to the stand.
Please come forward.
If you all would raise your right hands when you're ready. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Mr. Welborn, I just remembered one thing. I was giving y'all a schedule earlier on Thursday morning. We're having our weekly commission business meeting at 9 o'clock. So we will probably not start at 9:30 on Thursday. We will probably start about 10. So just wanted to let y'all know, and that just slipped my mind earlier. Thank you.
Thank you, sir. And if it pleases the commission, I'll do my direct examination from this side of the room, if that's
Anywhere you want.
Thank you.
Chair Powers,
Commissioner Thomas.
I would like to hear from the witnesses when they're sworn in as to whether they plan to be back, or is this our only time that we're going to see them?
They are sworn in, so Mr. Welborn, you can address that, I imagine.
Thank you, Chair. And we have handed out copies of the testimony summaries and associated graphics. Good afternoon, Mr. Chair, or morning at this point, Mr. Chair. Ms. Smith, we're going to start with you. Would you please state your name for the record?
Heather Shirley Smith.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy, and my title is Vice President of Regulatory Affairs and Policy for South Carolina.
Thank you. And how long have you worked for Duke Energy?
I've worked for Duke Energy since 2011.
And how long have you held the current position that you're in?
Since November of 2021.
What was your position prior to that?
I was Deputy General Counsel at Duke Energy, and I practiced in both North and South Carolina until the time that I took my current role. But in the last 5 or so years of my position, I focused exclusively on South Carolina.
And where did you attend? Where did you attend college?
I graduated from Emory University in Atlanta, Georgia, and I went to the University of South Carolina School of Law.
Are there any other qualifications that you would like to share with the commission this morning?
Yes, so I started practicing law in 2002, and I have been in rooms like this for over 20 years at utility commissions here, of course, which is, of course, my favorite, as well as in Georgia and in North Carolina. And over that time, I've seen a lot of IRPs, customer complaints, trade secret type of issues, different states' equivalent of Siting Act procedures, rulemakings, rate cases, of course, fuel cases. I could probably give a longer list, but it's given me a long, long history of seeing the types of regulatory matters that come before commissions and that are integral to a regulated utility's ability and obligation to serve its customers.
Thank you, ma'am. Do you believe that your testimony this morning will be helpful to the commission in its understanding the facts and issues in this proceeding?
I do, and it's certainly my hope, and that was my intent when I wrote it.
Thank you, ma'am. Chair Powers, I would move to qualify Ms. Smith as an expert in the area of regulatory policy.
She is qualified as an expert in regulatory policy. My understanding of those testifying as to facts, not the law.
Yes, sir. Thank you.
Okay, thank you.
Ms. Smith, did you prepare or cause to be prepared 49 pages of direct testimony that were pre-filed with the commission in this proceeding on October 24, 2023?
I have, yes.
Do you have any changes or corrections to that pre-filed direct testimony at this time?
I have 3 minor corrections. On page 2 of my testimony, line 11, it states that I earned my bachelor's degree in English and business. That should be I earned my bachelor's degree in English and studied business. On page 8 of my testimony, line 10, I refer to 6 combustion turbine generating units. That should be 4 instead of 6. On page 14 of my pre-filed direct testimony, that's at line 19, I refer to almost 9 gigawatt hours. That should be 9,000 gigawatt hours. And those are my corrections.
Thank you, ma'am. Subject to those corrections, if I asked you the same questions contained within your pre-filed direct testimony this morning, would your answers be the same?
Yes.
Chair Powers, I would ask that Ms. Smith's pre-filed direct testimony, subject to those corrections, be entered into the record as if given orally from the stand.
The pre-filed direct testimony of Ms. Smith will be entered into the record as corrected as if given orally from the stand.
Thank you, sir. Ms. Smith, did you also prepare or cause to be prepared one exhibit, which was the South Carolina chapter of the IRP?
Yes.
Do you have any changes or corrections to that exhibit at this time?
I do not.
Chair Powers, I would ask that Ms. Smith's pre-filed exhibit be entered as the next hearing exhibit.
The pre-filed exhibit of Ms. Smith identified as Smith Direct Exhibit 1, marked for identification, will be placed in the record as Exhibit number 2.
Thank you, sir. Ms. Smith, did you also prepare or cause to be prepared 15 pages of supplemental direct testimony that was pre-filed with the Commission on January 31st, 2024?
Yes.
And if I asked you the same questions that were contained within your supplemental direct testimony this morning, would your answers be the same?
Yes.
Chair Powers, I would ask that Ms. Smith's pre-filed supplemental direct testimony be entered into the record as if given orally from the stand.
Chair Powers, I apologize, but with the motion to strike still outstanding, I did want to renew ORS's objection to the admission of page 14, line 23 through page 15, line 4 of Witness Smith's supplemental direct testimony.
Objections noted. The pre-filed direct supplemental testimony of Ms. Smith will be entered into the record as if given orally from the stand.
Thank you, sir. Mr. Snyder, would you please state your name for the record?
Yes, my name is Glenn Snyder.
And by whom are you employed and in what capacity?
Duke Energy as Managing Director of Integrated Resource Planning and Analytics.
And did you prepare or cause to be prepared 38 pages of direct testimony that was pre-filed with this commission on October 24th, 2023?
Yes, I did.
If I asked you the same questions that were contained within your pre-filed direct testimony this morning, would your answers be the same?
Yes, they would.
Chair Powers, I would ask that Mr. Snyder's pre-filed direct testimony be entered into the record as if given orally from the stand.
The pre-filed exhibit, the pre-filed direct testimony of Mr. Glenn Snyder will be entered into the record as if given orally from the stand.
Thank you. Mr. Snyder, did you also prepare or cause to be prepared 3 exhibits labeled Snyder Direct Exhibit 1, Snyder Direct Exhibit 2, and Snyder Direct Exhibit 3, which were pre-filed in support of your direct testimony?
Yes, I did.
Do you have any changes or corrections to those pre-filed exhibits at this time?
No, I do not.
Chair Powers, I would ask that Mr. Snyder's pre-filed exhibits 1, 2, and 3 be entered as the next composite hearing exhibit.
The pre-filed exhibits of Witness Snyder, known as Snyder Direct Exhibits 1 through 3, are marked for identification, will be placed in the record as Exhibit number 4. I may not have stated it. Smith's supplemental will be Exhibit number 3. This will be 4.
Thank you, sir. Mr. Snyder, did you prepare or cause to be prepared 11 pages of supplemental direct testimony that were pre-filed with the Commission on November 30th, 2023?
Yes, I did.
And if I asked you the same questions that were contained within your supplemental direct testimony this morning, would your answers be the same?
Yes, they would.
Chair Powers, I would ask that Mr. Snyder's pre-filed supplemental direct testimony be entered into the record as if given orally from the stand.
The pre-filed direct supplemental testimony of Mr. Snyder will be entered into record as if given orally from the stand.
Thank you. Mr. Snyder, did you also prepare or cause to be prepared 30 pages of second supplemental direct testimony that was pre-filed with the Commission on January 31st, 2024?
Yes, I did.
And do you have any changes or corrections to that testimony at this time?
I have one minor correction. On page 5 of my pre-filed second supplemental direct testimony, line number 15, I refer to facilities using nearly 7,900 megawatt hours of annual energy. That should be 7,900 gigawatt hours, GWH, of annual energy.
Mr. Snyder, subject to that correction, if I asked you the same questions that were contained within your second supplemental direct testimony this morning, would your answers be the same?
Yes, they would.
Chair Powers, I would ask that Mr. Snyder's pre-filed second supplemental direct testimony, subject to the noted correction, be entered into the record as if given orally from the stand.
The pre-filed supplemental second direct testimony of Mr. Snyder shall be entered into the record as if given orally from the stand.
Thank you, sir. We're getting close. Mr. Snyder, did you also prepare, cause to be prepared, Snyder's second supplemental direct exhibit 1, consisting of the supplemental planning analysis, including its corresponding technical exhibits and other chapters?
Yes, I did.
Do you have any changes or corrections to that exhibit at this time?
No, I do not.
Chair Powers, I would ask that Mr. Snyder's second supplemental direct exhibit 1 be entered into the record as the next hearing exhibit.
Mr. Snyder's second supplemental direct exhibit 1 is, as identified, will be marked for identification and will be placed in the record as exhibit number 5.
Thank you, sir. We will now have these witnesses present their testimony summaries to the commission. Ms. Smith, we will start.
May I ask for a clarification, Mr. Chairman?
Certainly.
Was Ms. Smith's supplemental exhibit entered?
It was as exhibit number 3.
I thought that was the direct exhibit.
No, that's number 2.
Okay, I apologize. Thank you.
No problem.
All right. Do let us know if we miss anything. Keep us on our toes.
Chair Powers.
Commissioner Thomas.
Once again, I would just like to know from the get-go, are you going to be back or not? If each witness could just please answer that question once they're sworn in.
Yes, sir.
Yes, sir.
Thank you very much.
Yes, as in they will be back on the stand, not as in yes, they can answer the question.
Thank you.
Thank you, Chair Powers. Commissioners, Ms. Smith, we'll start with the summary of your pre-filed direct testimony filed in August of 2023.
Sure. Thank you so much. And good morning, Chair Powers and Vice Chair Williams and members of the Commission. Thank you for letting us be here this morning. In my direct testimony, I describe profound changes in the energy industry and how the companies are building upon the strength of their large and diverse dual-state systems to advance solutions that will enable the companies to reliably serve customers now and in the future. In the IRP before you, the companies have analyzed a variety of potential solutions to meet energy and capacity needs over the 15-year IRP planning horizon through 2038. And in developing the IRP, the companies endeavor to provide you the information needed, especially viewed through a South Carolina lens, to determine the most prudent and reasonable means at this time for meeting those energy and capacity needs. As I discuss in my testimony, the IRP statute contains language for the Commission to evaluate an IRP to determine whether it is the most prudent and reasonable plan at the time it is reviewed, and whether it appropriately balances the 7 statutory factors, which I believe we may be putting on the screen. These factors focus on resource adequacy and capacity, affordability and least cost, compliance with applicable regulations and law, reliability, commodity price risk, generation diversity, and other foreseeable conditions. These are what we refer to as the 7 balancing factors. In my testimony, I explained that the companies began stakeholder engagement for the IRP back in 2023 of February, holding 5 sessions over the course of 4 months and including more than 100 individuals representing customers, environmental advocates, community leaders, and other industry representatives. The IRP team then began work developing an IRP that complied with the South Carolina balancing factors, our obligations in North Carolina, and applicable federal law. Economic development growth in the Carolinas also plays a role in the company's resource planning. The size, scale, and speed of projects coming into the Carolinas since our last comprehensive IRP was filed are unprecedented. At the time we filed our IRP in August of 2023, we were seeing significant load growth from people moving to South Carolina, from economic development, and from growth in demand from electric vehicles. If we are to meet our existing demand, as well as this growth, we must continue to expand electric capacity across the state, including additional generation sources like natural gas, advanced nuclear, and renewables. At the same time as the company's generation needs are increasing to meet increasing load, we have aging coal units approaching the end of their useful lives that will need to be retired. We are not alone in that. All utilities in South Carolina are in the process of retiring coal generation, as detailed in the South Carolina chapter on page 31. I explained that this IRP is also occurring against the backdrop of new federal environmental regulations impacting coal generation, including requirements on wastewater, air standards, and emissions limitations. These increasingly stringent environmental regulations coincide with a declining domestic coal supply, creating additional reliability and commodity price risks. Of course, retiring these plants over the next dozen years drives a need for urgency and action in the near term to respond to these factors and ensure power supply reliability. Accordingly, we are pursuing and siting new projects before retiring our aging plants, thereby protecting reliability and resource adequacy, and also meeting that load growth that I discussed a few moments ago, especially as you think of those retired coal plant sites being ideal locations for additional infrastructure to continue serving our customers. The companies were mindful that any plan developed must align and be grounded in South Carolina law and policy, and my testimony explains how we did an in-depth look at the directives of the IRP statute, as well as the express legislative and policy direction of the General Assembly and state leaders, including the South Carolina State Energy Plan Statute, Act 220 of 2022, Governor McMaster's Executive Order number 2023-18, the creation of the Economic Development and Utility Modernization Committee, the Fuel Statute, and the CPRE Statute. In the South Carolina chapter of the IRP, which I sponsor and attached as an exhibit to my testimony, there is a lot more information on this view, as well as reference to the State Energy Plan Statute, Act 449 of 1992, which you can see on the screen. You can see that it early on established as the policy of this state to have a comprehensive state energy plan that maximizes, to the extent practical, environmental quality and energy conservation and efficiency, and minimizes the cost of energy throughout the state. It also includes several precepts that are supported by the company's IRP and recommended portfolio, including ensuring access to energy at the lowest practical environmental and economic cost, encouraging the development and use of clean energy resources, including nuclear energy, energy conservation and efficiency, and renewable energy, ensuring that energy-related decisions promote the economic and environmental well-being of the state, and ensuring that any energy strategy that promotes carbon-free, non-greenhouse gas-emitting sources includes nuclear energy, renewable resources, and energy conservation and efficiency. I believe that when you look at all of the references in the South Carolina chapter, it's clear that there are a variety of principles in South Carolina that indicate a focus on a cleaner energy future as well as economic development. Against this backdrop of a changing energy landscape and significant economic development growth in the Carolinas, and fully taking into account South Carolina law and policy, my testimony describes how the company set out to determine the most reasonable, least cost, and least risk path to meeting South Carolina's energy future. My testimony explains that of the dozens of portfolios modeled, Portfolio P3 is the portfolio we offer to the Commission, and we believe it is the portfolio that most appropriately balances the IRP statute's 7 balancing factors. Pages 25 through 31 of my direct testimony addresses how Portfolio P3 provides resource adequacy, supports affordability and least cost planning, complies with applicable state and federal law, supports reliability, mitigates commodity price risk, provides generation diversity, and addresses other foreseeable conditions. Portfolio P3 provides the additional capacity and energy needed for load growth across the company's system over the next 15 years. In addition to projects already in advanced development, Portfolio P3 includes plans for significant new generation, including combined cycle units, combustion turbines, solar, battery storage, advanced nuclear, pumped storage hydro, and wind. Portfolio P3 addresses energy needs over the next 15 years, including the actions set forth in the first 3 of those years, as described in the company's near-term action plan. In that plan, you can see that the companies intend to competitively procure substantial amounts of solar and solar plus storage, as well as develop standalone battery storage in the near term to be online by 2031. We are also taking steps over the next 3 years to pursue interconnection and obtain certificates for new natural gas generation, with operational dates targeted between 2029 and 2032. Our near-term action plan also showed that we will be continuing evaluations and planning to file certificate applications associated with an expansion of the Pad Creek pumped hydro facility, which would double the capabilities of the unit by 2034. We do plan to continue to evaluate nuclear technologies and take actions necessary in the next 3 years to be in a position to bring small modular nuclear generation online by 2035, and to screen sites for onshore wind and monitor developments for offshore wind resources, all while pursuing transmission investments. This near-term action plan is necessary to make sure we are taking the right steps at the right time to have resources online when we need them. We're asking the Commission to particularly focus on the near-term action plan, which explains the actions we will be taking between this filing and our next comprehensive IRP to meet our customers' energy needs. In my view, the IRP in our direct testimony supports Commission approval of Portfolio P3, including the company's near-term action plan, as the most reasonable and prudent plan put forth in this proceeding. Further, I believe that Portfolio P3 provides an executable plan to successfully navigate and serve the growth being experienced in the Carolinas in a manner that minimizes risk, prioritizes reliability and affordability, includes a diverse generation mix ranging from fuel-free renewables, innovative new resources, and dispatchable generation, provides for an orderly exit from coal generation, and helps customers meet their sustainability goals, which is important for South Carolina's economy, and importantly, complies with applicable South Carolina law and policy. Not only do I believe our recommended portfolio meets the balancing factors of the IRP statute and overarching state policy, our IRP is also in step with South Carolina's desire to continue to support economic development, and we have paid close attention to enacted statutes and executive orders that recognize the value and impact of these economic development projects on the state, as well as the associated energy demands of those customers, which include demands for renewable energy. The companies present Portfolio P3 for approval by the Commission in the interest of our system and customers, but it's important to note that the regulatory processes in place and applicable to our system will allow us to revisit this plan with you over the longer-term horizon, including annual updates, our triennial IRP filings, and approximately half a dozen comprehensive IRP filings with this Commission before 2038. Thank you.
Thank you, Ms. Smith. And as we've noted, in January 2024, we filed supplemental direct testimony for you. Would you please present that testimony summary to the Commission at this time?
Sure. In my supplemental direct testimony filed in January, I addressed the supplemental planning analysis the companies conducted to assess material developments, including the significant changes to the company's load forecast. We saw such tremendous growth coming over and above our expectations and historical experience that we had to file more information in this docket. According to the Census Bureau, South Carolina had the fastest growing population in the nation in 2023. I describe how South Carolina and North Carolina's continued efforts to attract jobs and grow the state's economy has produced unprecedented growth, and highlight that the size, scale, and speed of new projects coming into the Carolinas significantly accelerated after the companies prepared their initial IRP, which was filed back in August of 2023. While we were previously forecasting annual energy demand growth of 9% by 2033, we're now forecasting a 24% increase in annual energy demand by 2033 compared to prior IRPs. Companies like Duke Energy play a vital role in that growth, and we understand that having the resources to serve customers in South Carolina is a key enabler to that growth. The results of the supplemental planning analysis demonstrate that the significant resource additions over and above what the companies identified in their initial plan will be needed to serve these substantially increased capacity and energy requirements. And we call this portfolio P3 Fall Base as it incorporates our updated fall forecast. And I believe that we've provided that, and maybe you can see it on the screen, but we've also provided that as my understanding. If you look at that supplemental portfolio analysis results of the incremental additions needed by 2038, and you can also find this in my supplemental at page 7, you will see that P3 Fall Base introduces almost 7,300 megawatts of additional resources beyond our original filing, including additional solar, batteries, and natural gas generation, including one new CC unit to be sited in South Carolina, along with the potential for new to the Carolinas offshore wind, which would be located off the coast of North Carolina, building on the diverse portfolio of resources identified as needed in the initial IRP. I did want to point out the grid edge column there also includes the benefit of energy efficiency and demand response that puts downward pressure on those growing load needs. My testimony describes how Portfolio P3 Fall Base appropriately and reasonably addresses each of the IRP statute's 7 balancing factors and is the most reasonable and prudent plan to serve South Carolina's customers' future energy and capacity needs. In addition, South Carolina policy further supports approval of Portfolio P3 Fall Base because it accounts for the importance of economic development and growth to the state, as reflected in Section 3 of Act 220, as well as overarching state legislative actions discussed in Act 236 and other provisions of Act 62. It recognizes longstanding South Carolina energy policy as reflected in the Energy Plan statute. It adds additional generation in a way that is consistent with and supportive of recent state executive orders, and it makes reasonable efforts to minimize fuel cost as required by the state's fuel cost recovery statute. And it sustains the continuing need to effectuate a diverse and reliable set of resources to meet customer demands. Portfolio P3 Fall Base provides resource diversification and shields customers from risks related to fuel supply and fuel prices, while also meeting the growing capacity and energy needs of customers. In sum, Portfolio P3 Fall Base and its associated proposed near-term actions are reasonable to meet the robust growth and economic development that the companies are experiencing. I explained that clear Commission guidance on our IRP, including the near-term action plan, is critical. While the company's IRP is a long-term planning document identifying the resource needs for the next 15 years, it's necessary for us to take actions in the near term, namely years 1 through 3 of that 15-year period, to ensure adequate and reliable capacity exists to serve our customers. I explained that the companies have requested a Commission order affirming that the actions that the companies are undertaking are consistent with the public interest of South Carolina and supported by the Commission as part of the most reasonable and prudent plan to serve customers' future energy and capacity needs, including the need for cleaner energy resources that we hear expressed by customers and consistent with economic development trends. I testified in my pre-file testimony that the leadership of the state, the business community, and customers have laid the foundation for a vibrant and growing economy, which has made this state an attractive prospect for economic development, both from new prospects and customers who are doubling down on South Carolina and expanding their operations. Continuing to meet those challenges and opportunities while maintaining and improving reliability at competitive rates will require prudent and intentional planning, timely regulatory approvals, and decisive but balanced execution. I close my testimony by emphasizing that the companies are eager to continue their progress to help advance South Carolina's energy future. Finally, recognizing the robust IRP analysis and significant execution planning information presented in the company's IRP, the companies will be presenting testimony from an array of subject matter experts responsible for developing the IRP. We'll present that throughout the course of this hearing. For your benefit and the ease of reference, it's my understanding that Council has distributed a reference sheet which identifies our witnesses and their areas of expertise that will be appearing to answer questions about our plan. We look forward to answering your questions and explaining why we believe our recommended portfolio P3 fall base is the most reasonable and prudent resource plan for South Carolina customers. Thank you.
Thank you, Ms. Smith. Mr. Snyder, would you please present to the Commission the summary of your direct testimony filed with the Commission in August of 2023?
Certainly. Chairman Powers, Commissioners, really good to be with you today. My direct testimony sponsors the company's IRP, the overall resource planning framework, as well as the company's near-term actions plan resulting from the IRP modeling that the companies support as the most reasonable, least cost, least risk path for executing the company's IRP to serve South Carolina and North Carolina customers across the dual state system in the Carolinas. In Section 2 of my testimony, I explained that the 2023 is an integrated, system-wide plan designed to serve the needs of both South Carolina and North Carolina customers over the 15-year base planning horizon while prudently managing risks and uncertainties and navigating the complex and dynamic energy landscape of the future. In Section 3, I provide an overview of the Carolinas' changing energy landscape, including the significant and unprecedented level of economic development activity that has taken place in approximately the last 18 months. I describe the company's updated load forecast, highlighting that the extraordinary increase in load forecast is driven by three primary factors. One, economic development growth associated with several new large development sites. Two, rises in demand due to EV charging. And three, increasing growth in the number of residential customers to be served by DEC and DEP. My testimony also supports the critical importance of power supply resource adequacy to ensure reliable system operations and introduces the increased 22% planning reserve margin recommended in the company's 2023 resource adequacy study conducted by Astrape Consulting. Incorporating this 22% reserve margin in the IRP is necessary and prudent planning because it takes into account, among other things, increasing winter capacity risk, key cold weather events such as Winter Storm Elliott, and the decrease in neighboring balancing areas' ability to assist the companies during peak winter times, given neighboring systems themselves going through their own fleet transition. I explained that the company's IRP must plan for and execute on the development of a diverse set of resources that are reliable, commercially executable, and increasingly clean. This comprehensive planning and execution must be done against the backdrop of a changing energy landscape, which includes inflationary pressures, supply chain and labor market constraints, neighboring utilities making similar energy transitions, evolving state and federal regulatory and environmental policies, advancing technologies, and increasing interest in the source of energy by which they, increasing customer interest in the source of energy by which they are served. The company's IRP explains why it is necessary over the base planning period to minimize reliability risk and cost risk for our customers and provides a clear and thoughtful roadmap for a balanced, orderly transition during this critical execution period. Working with stakeholders, the companies have developed robust, comprehensive modeling and analysis designed to balance these many and sometimes conflicting considerations in order to minimize risk to customers. I highlight the importance of a diverse power supply portfolio, consistent with South Carolina's IRP statutes balancing factors, to provide a hedge to protect customers from resource costs and fuel volatility risks across the company's fleets. I then explain that while coal-fired generation has contributed to reliable and low-cost operations in the Carolinas for decades, there are increasing environmental regulations, fuel and supply chain risk, and operational challenges impacting the coal fleet. I discussed the IRP's plan to retire and replace over 8,400 megawatts of coal capacity by 2035. I highlight the critical importance of planning for and executing retirement of these remaining aging, less efficient coal assets while meeting the needs of a growing system. I then summarize our robust stakeholder engagement used to inform the IRP and provide an overview of the IRP pathways and portfolios as further addressed in Chapter 2 of the IRP. I think we'll have that on the screen as well. I explained that the companies developed the IRP to assess the 3 primary energy transition pathways, each pathway contemplating a different pace of energy transition and achieving different paces of coal retirements and carbon reduction relative to a 2005 baseline, also known as the interim target. In addition to developing a core portfolio under each pathway, the companies developed 13 portfolio variants derived from the core portfolios to explore different assumptions for resource availability and natural gas supply. 10 sensitivity analysis portfolios derived from Portfolio 3 base to explore the impacts on portfolio composition and costs resulting from changes to other input assumptions, as well as supplemental portfolios to explore potential impacts of the EPA Clean Air Act Section 111 proposed rule and to address planning inputs and scenarios identified for evaluation in previous IRP orders. In Section 4 of my testimony, I explain that the company's recommended portfolio, P3, is the most reasonable and prudent resource plan for South Carolina because it complies with state and federal laws, provides additional capacity and energy needed for load growth across the company's system while reducing risk to customers through the disciplined and orderly coal retirement schedule, expands the company's cost-effective energy efficiency and demand response options, and effectively meets reliability needs via a diverse portfolio mix. Section 5 of my direct testimony addresses the importance of this Commission's decision making on the resource plan, explaining that the guidance on recommended portfolio P3 and proposed near-term action plan will provide critically needed direction on how to progress IRP execution to reliably support South Carolina's energy future. This concludes my direct testimony.
Thank you, Mr. Snyder. We then pre-filed for you supplemental direct testimony in November of last year related to changes in the load forecast. Would you please present that summary to the Commission at this time?
Yes. My supplemental direct testimony filed November 30th, 2023 updates the Commission and the parties on substantial and material changes that occurred in the company's load forecast since the preparation of the company's IRP. I highlight the strong and unprecedented economic development in the Carolinas has continued since spring 2023 when the 2023 IRP was developed, and several new large economic development projects had made material commitments to the companies, warranting the need to develop an updated 2023 fall load forecast. Compared to the 2023 spring load forecast used to develop the 2023 IRP, the peak load growth in the updated 2023 fall load forecast increased by approximately 2,000 megawatts or 2 gigawatts. My supplemental testimony emphasizes the companies have the privilege and obligation to serve these new customers and recognizes the critical role reliable electric service plays in the economic vitality of the Carolinas. I then address the company's plan to make the updated 2023 fall load forecast information available in early December 23, and to further evaluate potential next steps in light of these increases.
Thank you, Mr. Snyder. And then in January 2024, we filed second supplemental direct testimony for you related to the supplemental planning analysis. Would you please present that summary to the commission at this time?
Yes. My second supplemental direct testimony filed on January 31st, 2024, sponsors the supplemental planning analysis, which assesses the impacts of the updated 2023 fall load forecast and identified additional resources needed to meet the increased load forecast. I explained that the supplemental analysis builds on and does not replace the initial IRP. The testimony provides an overview of the exponential economic development that has occurred since the filing of the initial IRP and highlights how the Carolinas' economic development success continues to drive the company's rapid and significant load growth projections, far exceeding the company's historic experience. Figure 1 in my testimony illustrates this dramatic load growth. Put that on the screen, may show up here. My testimony compares the updated 2023 fall load forecast to the load forecast used in the most recent 2022 South Carolina IRP update, as well as the 2023 spring forecast used in the initial 2023 IRP filing. It goes on to highlight that the pace and magnitude of change in the forecast in just over 2 years is unprecedented. I explained that interest in economic development sites in the Carolinas has also continued since the updated 2023 fall load forecast was completed, as engagement with potential new large site customers has continued into 2024. To plan for potential new economic development commitments that may occur, the supplemental planning analysis also includes a continued economic development load forecast scenario that analyzes the impacts of an even higher load forecast if similar economic development load growth trends continue into 2024 and beyond. I'd like to explain a couple of points of comparison here. Since the spring load forecast used in the initial IRP was developed, 27 incremental new major economic development projects, each exceeding 20 megawatts, have made material commitments to justify inclusion in the 2023 fall forecast. And that's what was used in the development of the supplemental planning analysis. Overall, the updated 2023 fall load forecast has resulted in approximately 2 gigawatt increase in projected winter peak demand for the 2023 spring, and approaches 5 gigawatts of increase relative to the 2022 IRP. The key takeaway from this recent and rapid load forecast growth is that the companies must now plan for the substantial new resources needed to reliably serve the material customer commitments included in the new forecast, while also analyzing and preparing for future potential economic development commitments beyond those included in the updated forecast. The supplemental planning analysis provides both of these important data points to the Commission. I then explained how the companies developed the supplemental planning analysis, which integrated other limited modeling inputs focused on resource cost, fuel supply, and executable resource availability assumptions. There is good news here. For example, advancements in the development of the Mountain Valley Pipeline since the August 2023 filing have provided the company sufficient certainty to treat Mountain Valley Pipeline as part of the base assumptions in the supplemental planning analysis instead of as an alternate fuel supply scenario as the pipeline was treated in the initial plan. The companies also performed an updated coal retirement analysis and economic verification of Bad Creek 2, which is a project we are looking at to potentially double the size of our Bad Creek pumped hydro facility. These topics are discussed in detail in the technical appendix to the supplemental planning analysis. Again, against this backdrop, the supplemental planning analysis presents 4 additional modeling portfolios under Pathway 3, including new recommended portfolio P3 fall base, which augments the initially filed portfolio P3 base. The supplemental planning analysis also provides supplemental updates to core portfolios under pathways 1 and 2, which meet interim targets by 2030 and 2033 respectively. In total, the supplemental planning analysis presents 7 additional portfolios, increasing the total number of resource portfolios in the plan from 33 to 40 portfolios, providing the Commission and parties with a thorough evaluation of the potential effects that a variety of future conditions may have on optimal resource selection and portfolio performance. The primary takeaways of the supplemental planning analysis are that 1, Pathway 3 continues to be the most reasonable, least cost, and least risk planning pathway, and as such, the companies recommend approval of P3 fall base as the recommended portfolio for future planning purposes. And 2, the pace, scope, and scale of incremental resource additions now required to meet the increased capacity and energy needs identified in the updated load forecast necessitate incremental additions to the company's near-term action plan, which includes a diverse portfolio of incremental solar, batteries, wind, combustion turbine, and combined cycle resource additions. To serve the incremental around-the-clock load that's predicted by 2038, the model selects 2,700 megawatts of additional hydrogen-capable combined cycle capacity in portfolio P3 fall base relative to the initial P3 portfolio, with the addition of efficient, high-utilization combined cycle capacity. Portfolio P3 fall base requires fewer peaking resources, reflected by a reduction of approximately 900 megawatts in the portfolio. To help meet incremental energy and capacity needs, the model also selects 2,900 megawatts of additional solar and 2,400 megawatts of offshore wind capacity that was not previously included in portfolio P3 base. Specific to offshore wind, I explained the companies need to gather more information that would be used to inform the acquisition structure, cost, and scale of offshore wind resources for consideration in the next comprehensive resource plan, recognizing that further analysis of the cost, timing, and need for long lead time resource will be very important before commitments are actually made. Next, I emphasize for the Commission that the supplemental planning analysis demonstrates how rapidly and materially the energy landscape can change, informing resource plan needs and related execution actions. During this critical period of load growth, the companies remain focused on their obligation to maintain and improve reliability through plan execution, ensuring resource adequacy with appropriate planning reserve margin levels. I discuss how portfolio P3 fall base is balanced and diverse portfolio that is well suited to meet the needs of both our existing customers as well as our new large high load factor economic development customers with a need for round-the-clock generation. Finally, I address the company's near-term action plan, which outlines the ongoing and planned near-term execution activities to develop the new resources previously mentioned, including new controllable solar generation, battery energy storage, wind generation, as well as new dispatchable gas combined cycle and combustion turbine projects that are under development. I note that the supplemental planning analysis increased the need for new gas combined cycle generation to 5 combined cycle units, achieving commercial operation between 2029 and 2033, and explain that the companies are now pursuing CC3 to be sited in South Carolina. I conclude by highlighting that progress on all identified near-term actions is now even more urgent in order to ensure adequate resources are available to meet customers' rapidly growing electricity needs and to meet growing economic development needs across our dual state system. I reiterate, the companies are seeking clarity from the Commission on the updated near-term supply-side development and procurement activities and to finding that they are reasonable next steps. As Ms. Smith stated, we look forward to answering your questions and explaining why we believe our recommended portfolio P3 fall base is the most reasonable and prudent plan for South Carolina customers. This concludes my testimony summaries.
Thank you, Mr. Snyder and Ms. Smith. Chair Powers, appreciate your indulgence. These witnesses are available for questions from other parties in the commission.
Thank you, Mr. Welborn, and thank you, witnesses. As far as cross-exam, let's start with Sierra Club.
Good afternoon.
Dorothy Jaffe on behalf of the Sierra Club. And this would be directed to you, Mr. Snyder, for your supplemental direct testimony on the bottom of page 8 and leading up to page 9.
I'm there.
Okay. And so that question that straddles those 2 pages states that are the companies considering new solutions with respect to serving these new economic development customers? Do you see that question?
Did you say supplemental direct on page 8?
Correct, yes. Starts at the bottom of page 8 and goes on to page 9.
I'm sorry, I might have a different, can you restate the question you're reading?
It says, are the companies considering new solutions with respect to serving these new economic development customers?
I'm sorry, I was in my second supplemental direct. I've got too many rounds of testimony.
First supplemental.
I'm there, I'm sorry. Yes, I see that.
Okay. So in the response to that question, you state that you're exploring opportunities to work in collaboration with these economic development customers to optimize the amount of new resources needed on the system to serve their new load. And you go on to say that you're partnering with customers on customer-sited generation. Do you see that?
I do.
Okay. And so would the accelerated clean energy tariff that the company announced in May be one of those new solutions that you're looking at to serve economic development customers?
That would be an enabler.
And that tariff would enable large customers to directly support carbon-free generation investments?
That's my understanding.
And it would also facilitate on-site generation at a customer's facility?
Subject to check.
Okay. And it's also my understanding, and I've gotten this information from your media press release, that it would also include a clean transition tariff that would match clean energy generation and customer load to accelerate overall grid decarbonization. Does that sound accurate?
Yes, it does.
And is the company planning to propose this new tariff in both North Carolina and South Carolina?
That's not my area of expertise. That might be a question for one of our witnesses, Mr. Duff, or
Yes, the answer is yes.
Okay.
So it may look a little different between the 2 states, but in both states, we're looking for partnership opportunities with our larger customers who have particular needs, and we look for win-wins with those customers as we look to meet their needs as well as the needs of the system.
Okay. And do you happen to know when that proposed tariff is going to be filed?
I don't. We've been talking to customers. And there are a different suite of tariffs. We also have some other tariffs. We were here talking about some customer-sided opportunities at an allowable ex parte briefing, which is not evidence. But we were talking about that. I believe it was in December maybe of this year. But those are the types of programs that we'll be bringing forth for commission consideration.
Okay. Thank you. No further questions.
Thank you very much, Ms. Jaffe. South Carolina Coastal Conservation League.
Thank you, Chair Powers. And Ms. Smith, my questions are mostly going to be directed to you. For the record, Kate Mixon on behalf of Say CCL, Upstate Forever, and Vote Solar. Ms. Smith, I just want to ask you whether a few statements are consistent with how the companies understand the role of integrated resource planning. Would you agree that an overarching purpose of an IRP is for the Commission to both stay informed about and shape the company's actions regarding resource planning?
Yes.
And do you think it would be appropriate for the companies to make significant resource decisions entirely outside the scope of an IRP or IRP update?
No.
And what the Commission orders in an IRP impacts what actions the companies take. Is that correct?
Yes. If I could just expand on that one moment. As a regulated company, we care a lot about what our regulators think, and we care a lot about the regulatory direction that we receive, and that's part of our responsibility. So I just wanted to underscore that.
And you agree that South Carolina's existing regulations and laws regarding cost recovery mechanisms, rate making, the Siting Act, or any other applicable laws would apply to any actions that the companies take following this IRP proceeding, correct?
Yes.
And would you agree the main overarching question in this IRP docket is about whether the company's IRP represents the most reasonable and prudent plan for its customers?
Yes.
A couple questions about what that standard means. To meet that standard, would you agree the company's IRP should be developed using methodologies that are vetted by experts and considered to be industry standard or best practice?
Yes, informed by any other guidance we have that may be more particular from the General Assembly or this Commission.
Would you also agree that the company's IRP should, as accurately as possible, reflect and try to minimize anticipated risks in operating its system over the planning period?
Yes.
And it should be developed using the best information available at the time?
Yes.
And so nobody, including the companies, can predict the future. Do you also think it's important that the company's plan be flexible enough that it can accommodate a variety of future scenarios?
Yes, and I will say if plans can change. It's important to have one, but it's important to be in a position to react to changing facts and circumstances, and we're held accountable for that.
And so I guess put another way, do you think it's important that the plan that the companies pursues leaves sufficient outs or alternatives so that the companies can change direction if they need to, if or when circumstances?
I do. I think it's important to have that direction. And I also think we have a lot of opportunities to check the plan, check ourselves, check what's going on in annual IRP filing updates to this Commission and our triennial IRP comprehensive filings that we make with the Commission. And in stakeholder engagement, that's a continuum that we pursue at various points.
Thank you. And so with that in mind, I also wanted to ask you a couple of questions about your testimony on the company's coal fleet. So in your direct testimony, you cite various risks associated with the continued operation of the company's coal plants. Is that correct?
Yes.
And those include federal air and water regulations, the age of the coal fleet, coal supply issues, and coal price volatility. Does that sound correct? Okay. Those risks are not entirely new, are they?
No.
And you'd agree that...
I do think that they have heightened recently. You can see that in bankruptcies from coal suppliers. You can see that in the rail companies backing away from coal. You can see that in less exploration and mining. You can see that in big price volatility swings. So I think there have been a variety of risks that have been in existence for a while, but we've really seen them heat up. And company witness Verderame has a lot of information on that as well. I also think there's not a lot of folks going to school to become coal engineers and work at coal plants. So labor challenges are also something that we see because it is a declining market. So I just wanted to underscore that.
And you kind of predicted my next question, which was that you'd agree operating the company's coal fleet has been posing increasing challenges for quite some time.
Yes.
Recognizing that the company's proposed dates for coal retirement have changed over time, Do you know for roughly how long that the company has been either actively retiring or planning for the retirement of its coal fleet in the Carolinas?
Before I got to Duke, I know for the last 10 years, we have been working on the retirements of our aging fleet, which include coal plants. And I mean, some of these plants are from the 1950s. So just wanted to underscore that.
Mr. Snyder, it looked like you may.
Well, I just wanted to maybe underscore, we're not just beginning to, we have already retired a significant number of coal plants in our fleet. We outline that in Appendix B to our filing, what our retired plants are, and we're continuing along due to the reasons stated by Witness Smith.
Thank you. And that trend, that predates any North Carolina legislation, does it not?
It does.
And it also predates the most recent Clean Air Act, Section 111 regulations on carbon emissions and the most recent federal ELG rules, correct?
It does.
So is it safe to say that even before those more recent developments, the entire utility industry in the United States is and has been moving towards coal retirement?
That's correct.
But the more recent actions add even more risk to continued operation of coal, correct?
It turned up the heat, I guess no pun intended there, but certainly that's true.
And I'm sure, as you both know, the companies and my clients have different views of exactly what this process should look like, but you would agree in general that retiring and replacing the company's coal units helps prevent exposure to unnecessary risk in the future, correct?
Yes.
And so in your view, is it a good use of the company's time or resources to explore portfolios that keep its coal fleet operating past the mid-2030s?
No, I don't think that's a good use of the company's time and resources, and I also think it moves away from where we wound up in our most recent rate cases. So we talk about useful lives of coal plants in our rate cases as part of our depreciation study. And the dates that we're talking about in our IRP are consistent with what the Commission has seen in depreciation schedules in our last DEP and DEC rate cases here at this Commission.
Right. Thank you both. And those are all my questions, Chair Powers.
Thank you, Ms. Mixon. Next, Carolina Clean Energy Business Association.
No questions for CECIBA, but thank you.
Thank you, Ms. Twitt. Walmart.
No questions, thank you.
Thank you, Ms. Eaton. ORS.
Thank you, Mr. Chair. ORS would like to reserve its cross-examination for these witnesses until they reappear on rebuttal.
Okay, that's fine. Commissioner Carolee Williams.
Thank you very much, Chair Powers. I wanted to start by just thanking you all for a good plan. I'm not really commenting on the content, but the organization, the graphics, the wordsmithing, I lived and breathed planning for a long time, and I just really appreciate it. And I appreciate it kind of from the perspective of, this is the second installment of a comprehensive plan, and it's an evolution, and we're all learning what it means. And so thank you.
Thank you, Commissioner.
Thank you.
And thank you for going back to the drawing board for the supplemental work and for agreeing with all the parties to have this additional time that we've taken. So thank you for that. Ms. Smith, you were sworn in as an expert from the perspective of regulatory. I lost my notes, but I wanted to ask you about kind of best management practices associated with IRPs. And from the perspective that they are evolving, I imagine, in other states. And I didn't know if you could add anything to the conversation about the near term or short term to the IRP as a whole, which is not defined in state. The shorter term element is not defined in state law. Is there anything that you would like us to know about that from a professional perspective?
Sure. I would say, these aren't your mother's IRPs anymore. And so, I would say maybe 15 years ago, You would look at an IRP and there would be, a single resource or just a small subset of resources that would be needed to meet growth. And your choices were limited. 15, 20 years ago, we were looking at, nuclear, and I say we, the utility industry. We were looking at, maybe nuclear. We were looking at natural gas. Not a huge interest in coal, although some coal has been built. Solar wasn't the resource that it is today. It wasn't as affordable as it is today. And there were other types of renewable nascent technologies. EE programs were not as mature and were not as sophisticated. I mean, in some places they didn't exist to help shrink the challenge of future load. So as the industry got more options, that's more options to consider. And that makes resource planning more complicated, especially with the advent of additional rules, regulation, and interest from customers, environmental groups, stakeholders, legislatures, really that kind of thing. So it has, over the course of my career, become a much more complicated process, but important for all of the reasons that we explain in our testimony. Stakeholder engagement didn't used to be a thing. When I first started practicing law, and when I first started dealing with regulatory matters, a company would put together its IRP, and to be honest, I think it might have been 10 years before I heard the phrase stakeholder engagement. That doesn't mean that utilities didn't care about what their customers or stakeholders thought. There just wasn't the type of process that we have today. Duke Energy is a leader in stakeholder engagement. They put a lot of time, thought, and resources to it. I mentioned in my direct testimony that we have over 200 people at Duke Energy that contribute to the IRP process, and you didn't used to see that, in my view, 20 years ago. So I hope I answered your question.
Well, I'm particularly wanted to drill down and really, I guess you're the expert. So I guess I particularly wanted any additional thoughts about the role of the short-term IRP and what you're seeing less from the Duke companies, but just being being as an expert and what you might be learning about in other states or with other utilities that might help us with some of this. To me seems like language skills related to the role of the approvals in the process. And I realize so I'm asking from the expert perspective, if you've got anything to add there.
I would say the biggest difference is the word urgency. And so the Southeast is undergoing an economic development boom. When we look around the states around us, I don't mean just North Carolina, I look at Georgia too. Georgia has recently brought Vogtle online, but it's not enough. They are rapidly needing to grow their system to meet economic development opportunities. So when you layer that on top of really the industry has some aging units that are approaching retirement, it creates a different urgency and a different focus on those first years of a utilities plan because, I think what is the saying, a goal without a plan is a wish. And so we're in the place where we have to plan and act, and we want to be transparent about what that is, particularly in those near-term years. So I think that's one of the contributors to why you see more focus on a near-term action plan. We've also learned a whole lot more about supply chain challenges, pipeline challenges, a variety of other challenges that necessitate utilities making sure they have the right place in line for people, products, vendors, resources to pursue the types of assets that they will need in the short term and the longer term. I know Mr. Snyder has spent a lot of time studying the types of issues that you're asking about, and I think he would have a good lens too as a IRP planner.
Yeah, I would just add, Commissioner, you've heard us over the years use the term check and adjust. And that's very possible with long lead time resources. So as Witness Smith alluded to, we'll have time to check and adjust on the timing and volumes of things like offshore wind or the exact timing and volumes of small modular reactions. We have to take action today to have those be an option. But with some of our near-term action plans, there's no more time to check and adjust. So the urgency and the priority of those activities that are outlined in our near-term action plan, we wanted to be crystal clear and transparent on what those activities were to ensure we had alignment with our customers and our regulators. And so that's I think what's evolved in near-term action planning is to be, very transparent. There's a lot more emphasis on the near-term action plan in the last couple of IRP cycles than we've ever had, in my career of doing this, which spans more than a decade. And so it's really to highlight those and get the clarity from the commission to ensure we're pursuing the right types of activities that we don't have time to check and adjust, that by the time we come back to you in the next comprehensive, these will be well under development. So that's really the focus on providing all the extra witnesses and effort and input into our near-term action plan.
Okay. Thank you. Just two more questions. Mr. Snyder, Witness Snyder, you talked about material commitment in your overview. Would you describe what that means from an economic perspective?
Yes, we talk about commitments from our large economic development customers, and you'll hear a lot over the next 2 weeks about the probability different amounts of load shows up. Is it going to be more? Is it going to be less? And so we look for customers that are materially committed to coming to Carolinas, that have signed a letter of intent or an energy service agreement, or have made other indicia like purchasing the land and permits and zoning and have construction underway. And that's what we meant by commitment. It's not just, hey, we're somewhat interested. It's no, we're committed to either expanding operations here in South Carolina, North Carolina as well, or new operations that we're bringing to the state.
Thank you. And Witness Smith, you brought into your testimony the state energy policy from 1992, which was enlightening. Is there any formal relationship between this IRP and that policy, and what is that relationship?
Sure. It's interesting because it's not in the code book that sits on my desk. I've got Title 58 on my desk, as long as our lawyers don't take it back from my desk. It'll be there. But I've got Title 58, and of course this is Title 48. And so what we did, understanding the homework we got in the last IRP order that Mr. Welborn mentioned, we wanted to make sure that we had our pulse on where South Carolina policymakers had spoken to these issues. And so this act came from the original IRP statute, and this is relative to the Energy Office. The last energy plan we had was, I think, in 2016. It's a little bit of a different function, so it's a little bit different. It does not supplant, in my mind, what we're supposed to do under the IRP statute of Act 62. And when I say that, I mean what we, the utility, are supposed to be doing. But they are, we do take them as guidance. We do take these expressions in the state energy plan policy as indicia of what's important to South Carolina and what we should be mindful of. And if our state leaders have codified it, we want to make sure that we're paying the right attention to it.
Thank you very much. No further questions. Appreciate it.
Thank you, Commissioner Williams. I think the rest of the commissioners are going to reserve their questions. Mr. Welborn, do you have any cross-exam at this time, or you want to reserve that?
No redirect, Mr. Chair. Thank you.
Okay, thank you very much. Now's a good time to break for lunch. If everybody could be back, let's say about 2:10. We'll resume at that time. We're adjourned.